Good morning, everyone. I think we can start now. Senator the Honorable Hazel Thompson-Nye, Minister of Parliament, the Honorable Frankie Campbell, Principal of the Eugene Depute Law School, Mrs. Tanya Bastian-Galanis, Magistrate Mrs. Cara Turnquest DeVoe, Superintendent of Police Dr. Chaswell Hanna, Mr. Tavares Smith, panelist and attorney at law, Ms. Jenna Christie, panelist and mental health therapist, Mrs. Nicole Sutherland King, director of the Legal Aid Clinic, Mr. Kevin Farrington, tutor of the Legal Aid Clinic, Mrs. Shanika Carey, president of the Eugene Depute Law School Students Association, faculty, students, staff, friends, guests of the law school, good morning. This session will now commence. And while waiting in anticipation for this session to start, I considered the vagaries of modern day technology. When it works, it's a thing of beauty. And when it doesn't work, well, it's inconvenient. But in context, it may not be so bad. The way it brought back memories. And if you can relate, I don't know if the chat is open, but let's see a comment in the chat. Bahamas Air, BWE, Air Jamaica, Liat, Last in Airport Terminal, Leaf Island anytime. If you've ever been on a delayed flight, nod where you are. I can't see it, but I can feel it. If you've ever been stuck in an airport because of mechanical difficulties, I want you to rock in your seat. And if you've ever driven to and from the airport or waited in the airport parking lot for loved ones coming from overseas who are supposed to reach and can't reach, keep your mics muted, but make some noise. This morning, we get to be in the comforts of our own environments. We get to go get a drink of our choice, some coffee, walk about as we wish, without someone telling us to remain seated with our seatbelts on. And so I thought maybe it's not so bad after all, but I do wish to apologize to all for the technical difficulties experienced this morning. That was the cause of the delay. We do know that persons have hectic schedules and we apologize for the inconvenience. But like family waiting at the airport, let me tell you how glad and relieved I am that you are here. This is the beauty and the challenge of our online world. And so it is my task and pleasure to welcome everyone finally to this, the 5th day of the formal sessions of Legal Education Week 2021. And what a wonderful educational and eye-opening week it has been thus far. During this week, members of the bench, members of the bar, faculty, EDLS, law school students, LLB students from the University of the Bahamas, high school students have engaged in enlightening discussions and invigorating legal competition under the theme, Accessing Justice in a Whole New World. This morning's session, Juveniles and the Law, the juvenile justice system in the Bahamas, promises to be just as informative and engaging. The matter of juvenile justice should be everyone's concern. Each year, many youth offenders are brought before the courts and end up in the justice system. A justice system that traditionally focused primarily on punishment is thankfully making steps towards more rehabilitative goals today. If we understand that human beings make mistakes and that young people are particularly vulnerable to making missteps, then I submit we ought to earnestly consider whether young persons, juveniles, should have their lives irrevocably ruined because of mistakes made before adulthood. We owe careful consideration and crafting of policies to them, to ourselves, and to society. And so I hope that you're as excited as I am to hear the contributions of our esteemed panelists. To take us through this morning's session is our moderator, Mr. John Carey, who I will now introduce to you. Mr. John Carey is a 6-month student at the Eugene Depute Law School. He's a lawyer admitted to practice in the Cayman Islands and the Republic of Fiji. John has lectured at university level in Jamaica and in Cayman. He completed his articles of clerkship in the Cayman Islands in 2016 and practiced law there until October 2017. He is currently attached to Monroe and Associates for the duration of the 6-month program. He is also the executive director of the Papua New Guinea Center for Judicial Excellence based in Port Moresby. In this role, John is responsible for judicial education and training of judges, magistrates, court staff, and the provision of continuing professional development opportunities for the law and justice sector in 15 countries in the Pacific Islands. He's an advisor to the Chief Justice of Papua New Guinea on matters related to judicial education and training, policy, case management, law reform, and is engaged in academic research in the area of access to justice. He regularly provides advice to the Chief Justices in the Pacific Islands on matters related to judicial education. John has done pro bono work in human rights in the Cayman Islands and was also a volunteer lawyer at the Family Resource Center in Grand Cayman, where he regularly provided free legal advice at a weekly legal aid clinic on a range of issues inclusive of employment, family, immigration, criminal, and land law. He was also a volunteer with the Meals on Wheels program. John was a junior achiever advisor in the Bahamas from 1996 to 2000. He also served as a member of parliament and parliamentary secretary in the Bahamas from 2002 to 2007. He's a Justice of the Peace for the Commonwealth of the Bahamas and a Commissioner for Oaths in Papua New Guinea. John is a member of the Commonwealth Magistrates and Judges Association, Fellow of the Commonwealth Judicial Education Institute, member of the Asia Pacific Judicial Educators Association, member of the Papua New Guinea Human Resource Institute, and a member of the Royal Papua Yacht Club. John has also been a member of the Bahamas Society of Engineers and Caribbean Water and Wastewater Association. He also serves on the advisory board of the Commonwealth Judicial Education Institute in Halifax, Canada, and is a representative for the Papua New Guinea Center for Judicial Excellence at the International Organization for Judicial Training, which has 125 member institutes from 77 countries. Distinguished guests, distinguished panelists, faculty, students, staff, friends and guests of the law school, please welcome Mr. John Carey. John. I'm seeing a note that Mr. Carey may have been kicked off the flight. So at this time, I'm told he's trying to log back in. So if you could give us Mr. Farrington.
Good morning. I think he got kicked off. He's out of the jurisdiction as well.
Well, I'll invite Mr. Farrington to introduce.
Morning, everyone. We apologize for our technical difficulties. Mr. Carey is actually in Papua New Guinea this morning, but I have the esteemed pleasure to introduce Mrs. Hazel Thompson IE. Mrs. Thompson IE taught me in Bar School, I think sometime between 2007 to 2009. And so, Mrs. Thompson IE, I'm grateful for you to bless us with your presence. Senator Hazel Thompson IE, attorney at law, consultant, mediator, and child rights advocate, graduated from the University of the West Indies with honors in 1980, and from the Hugh Wooding Law School with a legal education certificate in 1982. She holds an LLM degree with merit in family law from the University of London and a Master's of Science in Restorative Practices from the International Institute for Restorative Practices, and a graduate in school in Bethlehem, Pennsylvania. She also holds a certificate of completion with distinction in Gender and Development Studies from the University of the West Indies, Cayville, Barbados, a certificate in Development, Law and Social Justice from the Graduate School of Development Studies, Institute of Social Sciences from The Hague, the Netherlands, and certificates in Civil and Family Mediation from the Dispute Resolution Foundation in Jamaica and the School of Dispute Resolution in Atlanta, Georgia, respectively. She also has a certificate in Advanced Mediation from the Institute for Dispute Resolution in Malibu, California, and in Restorative Justice Leadership Development from the International Institute for Restorative Practices. Mrs. Thompson I possesses a diploma in Human Resource Management, and as well, she also has a teaching certificate. Senator Thompson I has served on the boards of many organizations, including Deputy Chairman of the Children's Authority, the Adoption Committee, and other committees of the Children's Authority, the Legal Aid Clinic, Advisory Authority, the Police Complaints Authority, the St. Dominic's Children's Home, UWI Credit Union, and Cathedral Credit Union. Without further ado, Mrs. Thompson I. I think your mic is muted, Senator I. Your mic is muted.
Are you hearing me now?
Yes, we can.
All right. Good morning to everybody. All protocols observed. I know I shouldn't say that, but in the interest of time. And thank you, Mr. Farrington. It's good to see you again. When students tell me that, I told them when I meet them in Parliament or whatever, I get a little worried, to know what I put out there. But I understand that you're doing quite well, and I'm proud of you. Now, it was with great pleasure that I accepted this invitation to address you on a topic close to my heart: juvenile justice reform, a Caribbean perspective. It is fitting that I should return to the Bahamas, although virtually, to address you on this topic, because it was Mrs. Tonya Galanis, then a relatively newly minted principal of Eugene Pugh Law School, who in 2010 demonstrated her faith in me and gave me support to conduct my first workshop in juvenile justice. Madam Principal, I thank you for that opportunity. I must tell you that since then I've organized many such workshops in Trinidad and Tobago regionally and internationally. Juvenile justice has been described as the unwanted child of state responsibilities. It's generally given little attention. As far as I know, Eugene Pugh Law School is the only law school of the Council of Legal Education to include juvenile justice on its syllabus and to set an examination in that area in the Criminal Practice and Procedure course each year. Thank you, Mr. Guy. I heartily congratulate Eugene Pugh Law School on organizing this webinar. I wish to tell you that many people from Trinidad and Tobago are logged in. They said they were registering because they're very interested in this topic. Juvenile justice is relatively new to the justice system. Until the first juvenile justice court was created in 1899 in Chicago, Illinois, children were tried as adults in the criminal courts. I was fortunate to attend the 100th anniversary of the juvenile court in 1999 in Chicago. What a wonderful experience it was to sit with people of like minds who wanted to give children a second chance. We heard success stories of people like Ella Fitzgerald, who had been an inmate of a juvenile detention center. Her father had died. Her mother's boyfriend abused her. She ran away from home and was placed in a correctional facility in upstate New York. How many Ellas do we have in our detention facilities in the Caribbean and around the world? I met a very personable teenage boy in a boys training center in this region. He had a rap sheet longer than his arm. He had been sexually abused by his mother's friend. When he told his mother about it, she accused him of lying. Soon after, he began to get into trouble with the law. Let's call him Tom. How many Toms do we have in detention centers in the Caribbean? The Mighty Sparrow sang a calypso about a Congo man. And let me tell you about my foray into my journey into juvenile justice. So Sparrow sang, I envy the Congo man. He better than me. I wish I could have gone and shake his hand. Now, I too wish to shake the hand of a Congo man. Not Sparrow's Congo man, and for entirely different reasons from those conveyed in Sparrow's salacious calypso. I wish to say thank you, sir, and shake the hand of a native of the Democratic Republic of Congo and former area representative of UNICEF Eastern Caribbean Office, Professor Ndolam Ngokwe, a most erudite man who ignited my passion for juvenile justice. In 1999, he selected me to coordinate a team of researchers to conduct a review of the juvenile justice laws, policies, and practices in the Caribbean. We were to assess the state's level of compliance with the United Nations standards and norms in juvenile justice, namely the Convention on the Rights of the Child, which all of us have ratified around the Caribbean, the United Standard Minimum Rules for the Administration of Juvenile Justice, which is called the Beijing Rules, the United Nations Guidelines for the Prevention of Juvenile Delinquency, called the Riyadh Guidelines, and the United Nations Rules for the Protection of Children, the Liberty, which is called the Rules, and sometimes the Havana Rules. And we were to make recommendations with regard to reform if necessary. At the time, I thought I knew the applicable law, the offenses that juveniles committed, the penalties imposed by the courts. In fact, I've been representing juveniles in court. I knew the general principles of the CRC, Article 2, non-discrimination, Article 3, best interest of the child, Article 6, the child's right to life, survival, and development, and Article 12, the child's right to be heard. And I knew that it governed everything we did with and for children. I had accepted an invitation to deliver addresses on children and crime in the Caribbean at the International Conference of Criminology and Criminal Justice in Barbados in 1998, and alternatives to sentencing juveniles at the Penal Reform International Conference in London University in 1999. But it is only when I undertook that UNICEF assignment, I realized I knew nothing about the special principles governing juvenile justice. I had never heard about the age of criminal responsibility and doli incapax, although Latin was my best subject at school. I had never heard about status offenses. But here I was, accepting the responsibility of guiding a team of law professors, a former attorney general, and prominent lawyers in assessing Caribbean juvenile justice. Now, I soon discovered after the first meeting that my team knew even less than I did. So I burned the midnight oil to light the way to our collective enlightenment. Enthusiastically, we set out on a voyage of discovery, but unlike Christopher Columbus, we knew not only where we wanted to go, but we were able to navigate our way to arrive there successfully. The study we undertook involved 15 Caribbean countries: Anguilla, Antigua and Barbuda, Barbados, Belize, British Virgin Islands, Dominica, Grenada, Guyana, Montserrat, St. Kitts and Nevis, St. Lucia, St. Vincent and the Grenadines, Suriname, Turks and Caicos Islands, Republic of Trinidad and Tobago. I have no idea why the Bahamas was not included. At the end of the study, I was asked by UNICEF to coordinate a symposium in Port of Spain at which we revealed the findings of our study. This symposium was funded by UNICEF Caribbean Area Office in collaboration with the United Nations Drug Control Program and Penal Reform International. Delegates came from all around the Caribbean region. They comprised attorneys general, staff from the AG's Department, Ministry of Justice, magistrate, court officials, police officers, prison officers, probation officers, social workers, representatives of children's home and other persons concerned with juvenile justice. Bahamas was not left out this time because it was represented by Mr. Orlando Wellington. He was then chief counsel at the Office of the Attorney General. So some of you may know him. Now, at the end of the symposium, we produced a number of recommendations, which we compiled in a document titled The Caribbean 2000 Consensus on Juvenile Justice. And I'll go through those recommendations. And then what I propose to do is to look, to see how far those recommendations have been implemented. The first one in the Caribbean 2000 Consensus on Juvenile Justice was that all states should review and reform their legislation to comply with the Convention on the Rights of the Child and related instruments. I've told you what the related instruments were before. Next one, that legislation be enacted in all jurisdictions to ensure that all children under the age of 18 are afforded the full protection of the juvenile justice system. Next, all Caribbean states, legislation should be enacted to the effect that the age of criminal responsibility shall not be less than 12 years of age. Next, a variety of measures be utilized in all jurisdictions to divert juveniles from the criminal justice system. Next, that states were to establish juvenile or family courts or strengthen the existing juvenile courts without delay. Next, all juveniles are to be provided with legal representation at the earliest stage of proceedings. Number 8, now steps be taken for early abolition of corporal punishment of juveniles in all countries where it still remains a legal punitive sanction. Next, deprivation of liberty must be a measure of the last resort and for the shortest possible time within the juvenile system. All states must ensure the provision of sufficient human, social, financial, administrative, and physical resources for the effective functioning of the juvenile justice system. Next, a regional task force, including international organizations, should be set up to continue collaboration on juvenile justice issues, and that the issue of juvenile justice reform be placed as an urgent item on the agenda of the meetings of CARICOM Legal Affairs Committee, Council for Human and Social Development, and the relevant organs of CARICOM. And that a standardized regional data collection system on juvenile justice be established. And finally, that the issue of training of personnel throughout the criminal justice system be accorded priority action. That's what you're engaging in now, training. The recommendations are, of course, not exhaustive of the list of rights in the child justice process. There are other rights to be honored: the right to have one's dignity respected, the right to privacy, to be separated from others, to have the matter determined without delay, to the presumption of innocence, to be informed of charges, to be protected from self-incrimination, to parental support, and all other due process rights to which adults are entitled. Now let's look at the first one, a separate legal system for juveniles in conformity with the CRC. Remember, that's the Convention on the Rights of the Child. This dovetails right into Article 43 of the CRC, which requires that state parties shall seek to promote the establishment of laws, procedures, authorities, and institutions specifically applicable to children alleged as accused of or recognized as having infringed the penal law. Unlike Shakespeare's Juliet, who said to Romeo, "What's in a name? That which we call a rose by any other name would smell as sweet." Juvenile justice experts believe a name is important. The name generally given to the justice process involving children is juvenile justice. The view is that the word juvenile has negative connotations. It is stigmatizing. It tends to highlight the child's behavior rather than have us view a child before the court as a child in need of care and assistance. Nikhil Roy, formerly of Penal Reform International, in his paper which he delivered at the World Congress of Juvenile Justice in Geneva in 2015, to which UNICEF facilitated my attendance. Thank you, UNICEF. I know you're listening, UNICEF Barbados. He described the situation as one where the crime overshadows the child. We forget it's a child we're dealing with. We think about how heinous the crime is. So a vital first step, therefore, in juvenile justice reform is a change in name from juvenile to child justice. In many Caribbean countries, the law applicable to children in conflict with the law has undergone a name change. The OECS, the Organization of Eastern Caribbean States, produced a model bill dealing with juvenile justice and named it the Child Justice Bill. And this has been enacted with modifications in various OECS. So we have a Child Justice Act in Grenada, Child Justice Act in Antigua and Barbuda, in St. Vincent and the Grenadines. Now, other states departing from the juvenile justice nomenclature have chosen to name their legislation differently. So there's the Child Care and Protection Act 2004 in Jamaica, Child Care and Protection Act 2007 in the Bahamas, the Child Protection Act 2017 in Christopher and Nevis. In Trinidad and Tobago, our law can be found in our Children Act 2012 and our Family and Children Division Act 2016. BVI has Children and Young Persons Act and the Cayman Islands Youth Court Act. The next point I want to look at is protection of juvenile justice systems to children under age 18. The CRC defines a child as every human being below the age of 18 years unless the applicable law to the child majority is attained earlier. Now, the age of majority regionally is age 18 in Caribbean states. Some Caribbean states now, following Old English law, have separated the child into persons under age 14, and from 14 to 16, they name the child a young person. And they do not extend protection of child justice to children above age 16 years. Barbados and Montserrat, I believe, fall into that group. The British Virgin Islands now defines young person as a person who has attained the age of 14 years, but is under the age of 18 years. Most jurisdictions, however, like Belize, have amended their laws to define a young person as a person 16 years of age or upwards and under the age of 18 years. Others simply define a juvenile or a child as a person under or below the age of 18 years. Dominica, Jamaica, Grenada, Trinidad and Tobago, Antigua and Barbados, St. Vincent and the Grenadines, St. Christopher and Nevis. The Bahamas, curiously, has three categories of child. First, you have a child as a person under the age of 14 years. Then you have juvenile, a person who has attained the age of 10 and is under 18 years. And then you have a category, young person, a person who has attained the age of 14 and is under the age of 18 years. Now let's look at the age of criminal responsibility. If you remember, the recommendation is that it should not be less than 12 years of age. The age of criminal responsibility is the age below which a child is presumed to be incapable of committing a crime. The child is said to be duly incapax, incapable of doing wrong. That presumption is irrebuttable, so you cannot bring any evidence to the court to show that a child below that age knew that what he was doing was seriously wrong and should be prosecuted. The irrebuttable duly incapax rule is usually framed in these words: it shall be presumed that a child under the age of 12 years is not capable of or guilty of committing a criminal offense. There is also a common law rebuttable presumption that a child between the age of criminal responsibility, whatever it is in your jurisdiction, and 14 years is duly incapax. But it is rebuttable, so the state can bring evidence to prove that such a child knew that what he or she was doing was seriously wrong, and if it is proven, the state can then prosecute that child. Some jurisdictions have legislated the rebuttable duly incapax rule, which states a person over the age of 12 years and under the age of 14 years shall not be criminally responsible for an act or omission unless it is proved that at the time of doing the act or making the omission, he or she had the capacity to know that he or she ought not to do the act or make the omission. I think that approach very helpful, as lawyers in the main seem unaware of the existence of this rule, with the result that it is honored more in the breach than in the observance. The common law presumption, that common law presumption of the rebuttable duly incapax rule was abolished in the United Kingdom by the Crime and Disorder Act 1998. I wish I could give you the lead up to that, but we don't have much time. But I must say that the Bahamas is the only other jurisdiction I know of that has explicitly abolished the rebuttable duly incapax rule. As your legislation states in the Bahamas, it shall, in section 109B, it shall not be presumed that the child aged 10 or over is incapable of committing an offense. Article 43 of the CRC imposes on states the responsibility for the establishment of a minimum age below which children shall be presumed not to have the capacity to infringe the penal law. The convention does not state what that age should be, but the Beijing rules give some guidance. It states in Article 4, the beginning of that age shall not be fixed at too low a level, an age level, bearing in mind the facts of emotional, mental, and intellectual maturity. When the 2000 consensus was drafted in 2000, very few Caribbean states had an age of criminal responsibility of 12 years. We had Belize, St. Lucia, and Dominica. After law reform today, the age of criminal responsibility has been raised to age 12 in Jamaica, Grenada, St. Vincent and the Grenadines, St. Christopher and Nevis, Antigua and Barbuda. Barbuda didn't get it right initially, Antigua and Barbuda, but they amended the law in 2018 to raise the age to 12 years. Barbados has a draft bill and hopes to get there soon. The Bahamas Child Protection Act sets the age of criminal responsibility at age 10 years. Montserrat is also 10, Turks and Caicos 8, and the Republic of Trinidad and Tobago retains a disgraceful age of 7 years, which was the common law when we enacted our Children Act in 1925. I was at my office one day at Eugene Pearce Law School and the phone rang. The caller was Don Cipriani from the Netherlands. He was a PhD student then and had come across my name during his research and wanted my help on the age of criminal responsibility in the Caribbean. I assisted him, and Dr. Cipriani was kind enough to acknowledge me on page 371 of his books, Children Rights and the Minimum Age of Criminal Responsibility, A Global Perspective. And he sent me a copy. I was sad to see our low age of criminal responsibility exposed to all the world. The Committee on the Rights of the Child, the group of experts charged under Article 43.3 of the CRC with the responsibility to monitor states' implementation of the CRC, issued General Comment number 10, Children's Rights and Juvenile Justice in 2007, in which they recommended age 12 as the internationally acceptable minimum age of criminal responsibility. In 2019, the committee, after reviewing the findings of neurologists, revised that age to 14 years in General Comment number 24. So far, only Guyana has made moves to effect that change. Now, I must tell you, in Latin America, you have many of them 14, 16 years, some jurisdictions go right up. Now, let's look at the status offenses. Those status offenses are acts that are deemed offenses when committed by juveniles, but they are not considered such when perpetrated by adults. They include behaviors such as truancy, drinking alcohol, smoking, running away from home, and being beyond control of a parent. The abolition of status offenses would mean the child being diverted from court and into social welfare or some other intervention. Under the Children Act of Trinidad and Tobago, such children are termed chins, that is, children in need of supervision. In Guyana, they are termed in need of protective intervention and are referred to the director of the Child Care and Protection Agency for assessment and action. The RIAD guidelines, which is the guidelines I told you about before for the prevention of juvenile delinquency, provide that legislation should be enacted to ensure that conduct not considered an offense or penalized if committed by an adult should not be deemed an offense if committed by a child. According to Geraldine Van Buren, a well-known expert in child rights, recent studies conducted in a number of states show females were significantly more likely than males to be brought within the purview of the criminal justice system for status offenses. She views status offenses as being by nature paternalistic and could result in deprivation of liberty. Remember Ella Fitzgerald, what she was running from? And a number of children are running from sexual abuse in their homes, and they're put into institutions. They are being punished. The next point is the establishment of courts for children. It could be family, juvenile, youth court, or children court. That was a recommendation 6, that states should establish these courts to strengthen juvenile courts without further delay. And this accords with Article 43 of the CRC, that in all jurisdictions, children court cases are generally heard in special courts called juvenile court. In some cases, there's an exception when the adult is charged alongside a juvenile, or the charges are very serious charges as murder. All jurisdictions, including Bahamas, Montserrat, which still designate their courts by that name, have had juvenile courts for many years. Some now have family courts for adjudication of child justice matters. For example, Belize Family Court, I think is the oldest in the region in 1998. You have St. Lucia Family Court, St. Vincent and the Grenadines Family Court, Grenada Family Court. Trinidad and Tobago Family Court, established in 2004, did not assume jurisdiction for child justice matters, and those matters continued in the Magistrates Court. But Trinidad has now established a children court, which is dedicated to child justice. In the British Virgin Islands, child offenders have their matters heard in a youth court. So too Cayman Islands for child offenders between 16 and age 18 years. Now we look at the issue of legal representation for juveniles. Recommendation 7. And this should be provided at the earliest stage of the proceedings. When we look at the OACS Child Justice Act, they all include provision for legal representation for children. Although there is provision for an attorney at law to attend the assessment of a child which precedes an initial inquiry, the various Child Justice Acts provide that the child shall be provided with legal representation by the state at the conclusion of an initial inquiry if no legal representation was appointed by the parent or an appropriate adult. And the child is in detention pending trial, the proceeding is postponed for trial in the court, and is likely that a sentence involving a residential requirement may be imposed if the child is found guilty of the offense in question, or the child is over the age of 12 and under the age of 14, and a certificate pursuant to Section 5.3, that is where you have rebutted the Doli Incapax rule, has been issued. So when you look at these provisions, it is evident that legal representation is neither automatic nor guaranteed to all children before the court at the early stage of the proceedings. In fact, it's hemmed in with all of these conditionalities. In the Bahamas, the law makes provision for the child to be represented by a minor's advocate if it appears to the court that the child is in need of legal representation. It also makes provision for a child to be represented by a counsel. Jamaica's Child Care and Protection Act provides for a child in need of legal representation to be represented by the children's advocate or through legal aid, and Trinidad and Tobago has various provisions to fulfill the child's right to legal representation. We've had the Legal Aid and Advice Act, which since 1976 has provided for juveniles to be represented, because summary offenses is one of the areas where legal aid is granted. Many children, however, have appeared before the court, have seen them, and they've been unrepresented. Happily now the tide has turned, and there's an amendment to the Legal Aid and Advice Act, which provides for duty counsel to provide legal representation for a minor as soon as possible after the minor is detained on suspicion of having committed a capital offense or such indictable offense. In addition, we have the Children's Act, which provides for the Solicitor General to assign a children's attorney to represent and safeguard the interests of a child and perform such other functions as the court may think necessary. And the Family and Children Division Act empowers the court to appoint a guardian ad litem for a child. This act, also provides for application to be made to the court by the Children's Authority, the police, or the duty counsel to have a children's attorney appointed for a child who is a suspect or is being interrogated or is being investigated or is a witness. So that's an early stage. You can have representation. Article 42 of the CRC is what speaks to legal representation of children in court proceedings. Now let's look at abolition of corporal punishment as a punitive sanction. As a former coordinator of the Caribbean Coalition for the Abolition of All Corporal Punishment of Children, I can say that corporal punishment is a hard sell in the Caribbean. We love to beat children at home, at school, in institution, oblivious to the fact as a breach of human rights. When I was in Bahamas in 2019, I was on Paradise Island in the bank, and a woman was beating a child. I tried to stop her. She told me it's her business. Keep out her business. And we got into a little argument there. So my children usually tell Mommy, don't interfere, but I just can't let it pass. It's easier to get laws passed to increase penalties for children for cruelty to animals than laws to stop corporal punishment of children. All of us doing it all over. Article 37(8) of the CRC states, no child shall be subjected to torture or other cruel, inhuman, or degrading treatment or punishment. The European Court of Human Rights, in the case of Tyra in the UK in 1978, interpreted that provision as forbidding judicial birching of children. Now, despite all the findings of psychological associations, the worldwide advocacy of the United Nations Secretary General study of violence against children, the unrelenting work of the global initiative to end all corporal punishment of children. And general comments put out by the Child Rights Committee, corporal punishment has not been completely abolished from our homes and schools. But thankfully, there is some success in the child justice system, as laws sanctioning corporal punishment of children as a sentence has been repealed in many jurisdictions: Trinidad and Tobago, Jamaica, St. Lucia, Suriname, Haiti, British Overseas Territory, U.S. Virgin Islands, and Puerto Rico. It's not yet been abolished in Barbados, Dominica, St. Vincent and Grenadines, and I dare say the Bahamas. Now let's look at deprivation of liberty as a measure of last resort. The JDL rules defines deprivation of liberty as any form of detention or placement of a person in public or private custodial setting from which that person is not permitted to leave at will by order of judicial, administrative, or other public authority. So it's not just in prison, it could be in a hospital as well, a mental hospital. Children may be in detention when they are remanded awaiting evaluation or report or sentence at the pretrial stage, or if they have been committed to an institution. Deprivation as a measure of last resort can be gleaned from the wording of the Children Act of Trinidad and Tobago, which states, where a child is convicted of an offense and the offense is his first offense, the court may pronounce a custodial sentence only if convinced that the offense is so grave that no other punishment or course of action that is authorized to impose under this act is sufficient. And having regard to such information revealed pursuant to subsection 1, is in the best interest of the child that he be placed in an appropriate community residence. Previously, and this still obtained in some jurisdictions, children were remanded until age 18 years, and a review was not undertaken to remove the child even when seemingly rehabilitated, and even when the law provided for early release. Recent legislation in jurisdictions like Trinidad and Tobago reflect a new thinking and emphasize reintegration. A care plan is prepared for each child to determine the suitability of the response to child offending or child in need of supervision. This care plan must be reviewed periodically, but anecdotal evidence is revealing that shortage of human resources does not ensure that this is strictly enforced. Now, a variety of dispositions must be available so that the response to child offending is suitable to the offender and the offense. This principle of proportionality is an important component of child justice required under Article 44 of the CRC. Child justice must be individualized justice. The dispositions must accord with not only the seriousness of the offense, but also the circumstances and the needs of the child. And recently they've been saying the needs of society. Social inquiry reports are crucial to the choice of the measure to be imposed on a child. Now let's look at diversion from criminal justice system. The CRC mandates that wherever appropriate and desirable, measures for dealing with such children without resorting to judicial proceedings, providing that human rights and legal safeguards are fully respected, can be employed. Now, diversion may be used at any point of the process by a variety of decision makers. It can be the police, the prosecution, or the courts, but it must take place with the consent of the child offender and may take a variety of forms: police warning, police caution, community service, counseling, supervision and guidance, attendance centers, orders, fines, damages, costs, curfew orders. The Family and Children Division Act of Trinidad and Tobago, which created a special division of the High Court to deal with matters of families and children, introduced a new form of diversion, I dare say in the Caribbean, the court annexed peer resolution. A child who pleads guilty to certain offenses may consent to have his or her matter referred to peer assessors who will hear the matter and make recommendations to the court. The court may then accept the recommendation, may refuse it, or give reasons, or amend the recommended sanction. If the child fails to comply with the sanction, the child may be summoned to court or arrested and be dealt with by the court. The Family and Children Division also has a drug treatment court process to which children who are abusing alcohol or other substances may be referred. Although there have been many persons trained in restorative practices, especially restorative justice in Trinidad and Tobago, The Family Group Conference, which is a very successful diversion process that has proven to be successful in many countries and which is started in New Zealand under their children legislation and has been described as New Zealand gift to the world, has not yet been used in the child justice system in Trinidad and Tobago. The Family Group Conference, I said, started in the New Zealand Children and Young Persons and Their Families Act 1989, and it has been incorporated in the child justice laws of the OECS, South Africa, and a number of jurisdictions. Now, finally, I would like to talk about the training of personnel throughout the criminal justice system and provision of sufficient human, social, financial, and physical administrative resources for effective function of the juvenile justice system. Training must be an ongoing exercise. Some of you may be attending a training program for the first time today. Do not let it be your last. Within the last few years, Caribbean countries, including the OECS and Trinidad and Tobago, receive funding for training stakeholders in child justice, for reform of child justice programs, and physical facilities throughout by the United States Agency for International Development, USAID. We must hold governments and corporate society to account to honor their responsibilities for the future of our youth by scrutinizing their budgetary allocations to provide sufficient human, social, financial, and physical and administrative resources for the effective function of the juvenile justice system. That is money well spent. Now, many people up to today, even though the Convention on the Rights of the Child is 30 years old, still have problem with children having rights. And more so in the children having rights in the justice system. I would want to end my talk today by quoting John Eckler from Oxford University, my colleague with the International Society of Family Law, who wrote an article entitled "The Importance of Thinking That Children Have Rights." And he says, if all young people are secured all the physical, social, and economic rights proclaimed in the convention, the lives of millions of adults of the next generation would be transformed. It would be a grievous mistake to see the convention as applying to childhood alone. Childhood is not an end in itself, but part of the process of forming the adults of the next generation. The convention is for all people. It can influence their entire lives. If its aims can be realized, the convention can truly be said to be laying the foundations for a better world. I trust that at the end of this webinar, when you leave here, you will vow to do your best for children in the child justice system and all the systems that deal with children. Thank you for your patience. I know it's been quite a mouthful.
Thank you very much, Senator Hazel Thompson-Aye, for your presentation to the Eugene DePuy Law School. It was very informative and enlightening, and there are a number of questions that are being put forward to you if you're able to take some in the next few minutes. So at this time, we will open the floor for questions for Senator Thompson-Aye. First question, Madam Senator. Based on your experience, and this question is asked, and I will put the name of the person who is asking the question so it's not an anonymous question and answer session. This question is from Mrs. Shanika Carey. Senator Thompson-Aye, based on your experience in restorative justice, do you think it would be impactful if more emphasis was placed on restorative justice? I think, Senator, you'll have to unmute. Senator, I think your mic is still off, so we're unable to hear.
Are you hearing me now?
We can hear you now. Thank you.
Oh, good, good. Now, perhaps I can start by saying this. Restorative justice asks different questions. First of all, one always, when a child does wrong, you say, what happened to you? What's wrong with you? Sorry. But really, we ought to try to find out what happened in that child's life that produced that result. Restorative justice does not ask what crime has been committed. You're looking to see what is happening, and you always have that child being supported. You never send the child alone. The restorative justice always try to do what we can to fix the problem that is causing the child to behave in a particular way. You always send the child to a session with someone who can stand with that child. We have the community. We look at a wrong not as a law breaking, but that the community trust has been broken, that connection to the community. So what you want to do is to restore that child back to the community. You always have to hear the other side. So children do not always, and people sometimes don't believe it, see the consequences of their actions. So you always have the voice not only of the offender, but also the voice of the person who has been harmed to say the effect that that harm has on that person. And that has been, in many cases, found to be transformative. That you're hearing for the first time, you know, when you stole my car, my whole family was affected. I could not take my children to school. I had to impose on some other neighbor who was also affected. When my house was broken into, it affected the other neighbors. They became more fearful. So you must always show the consequences of what has happened. It also produces something in the, you don't always have to look for forgiveness, but many times you see the generosity of the person who has been harmed. And you see a change also in the offender, who is moved at times to offer an apology and to make amends. So it is not only a question of punishment, but how do you repay that society? Because the crime that is committed, the offense, is really an offense against the community. So it's a shift in thinking. It is not so much what law has been broken, but who has been harmed? Who has been harmed by my wrongdoing? That is what restorative justice wants the offender, the wrongdoer, to see. So it's a shift in thinking. It's a shift in emphasis. And at the end of it all, we want reintegration. We don't want that child to be cast out because that punitive culture that we have, a child does something in school, you expel the child, we have zero tolerance for bad behavior in school. Really, what we should be doing is trying to reintegrate that offender into the community. If something is done within the school environment and you call a restorative justice conference, that child could perhaps be made to do something in the school, whether it's to come in on Saturday and do some painting, some cleaning up, something to restore that community back to where it was. So it's not so much a law breaking, what law has been broken, but who has been harmed. That is what and how the emphasis of restorative justice, and that is what brings about that change in behavior and that reintegration. Yes?
Thank you, Senator. For the participants on this webinar, if you would like to ask questions, please place this in the question and answer chat feel free to place the questions there. Senator, we have a second question by Ebony Spain.
Yes.
And the question is, what is your view on the constitutionality of the uncontrollable child?
The constitutionality. Now, I'm not sure what is meant by the constitutionality of the uncontrollable child. What I can tell you is that when you lock away a child who is seemingly uncontrollable, you're looking at an infringement of the child's human rights unless we can show, so from that point of view, unless we can show that it is justifiable in the circumstances and it is for the best interest of the child, because everything we do is in the best interest of the child. If you lock someone away because that child is uncontrollable, you have the privation of the child's right to freedom of movement and all of those things. But when we're dealing with children, we always look to see what is in the best interest of the child. And of course, we have the question of discrimination as well. You must treat children equally. When I say equally, we're talking equity here because not every situation is equal. But you have to look to see that you treat the children fairly and always in the best interest, give the child the right to be heard. All of these are rights that the child has.
Thank you very much, Senator. We have time for 2 more questions given the time slot available for presentation and question and answer. The next question is from Chris Shanapu. Senator, you mentioned a care plan is developed for all clients. What goes into the plan? Who is involved in developing and implementing the care plan? How do we assure that all the partners play their role effectively in executing the care plan? That's a number of questions all rolled up into one.
Now, the care plan is usually prepared according to who's given responsibility in your legislation. So you have, it may be in our jurisdiction, you will have the Children's Authority. They may be preparing the care plan. You may have in some jurisdiction, you may have the probation services. So there will be some designated authority that will be preparing the care plan, and you will have different persons factor in to the care plan. So you may have the medical part of it, you may have the social, whatever the child's needs would go into the care plan, and the decision will be made as to what is the best thing to do with this child. So before we take this child away from the home, what are the options? So in looking at the entire situation, the plan would be drawn up. Maybe for the first month, the child will be put into foster care, and then it will be reviewed, and the child will be placed back with a parent, or we may find a fit person, we may find the child needs some kind of medical intervention or psychiatric intervention. So it would, the child will be looked at holistically, and the plan would encompass all that the child the child needs to go forward, to be, at the end of the day, the adult that will make a contribution to society. So it's an individual plan for each child, because each child's situation is different. And you have to decide in your legislation who is going to decide who is going to have responsibility for preparing the care plan. It is very rarely just one entity. If it is one entity, that entity would have several components, because a child is made up of, several components. You have the mental, you have the physical, you have the education, and all of those things that the child needs would go into the plan.
Thank you, Senator. Another question for your consideration. This is from Tamika Roberts. Good morning, Mrs. Thompson-Aye. My question for you this morning is based on juveniles who committed the most serious crimes, such as murder and armed robberies. How should the juvenile justice system restore and rehabilitate them to be reintegrated back into society?
That is always a problem with the heinous crimes. But we must never let the crime, as Nikhil Roy said, who used to be a penal reform, my good friend from Penal Reform International, never let the crime overshadow the child. No matter how heinous that crime is, it is still a child who has committed the crime. And remember I spoke about the 100th anniversary of the juvenile court in Chicago? They came up with, to celebrate the 100th anniversary, a book called Second Chances. I have a copy here. And that gave a number of stories of children who had committed, they had been, confined to juvenile hall because they had committed a series of offenses. And these children were rehabilitated. Some were working in the government in the United States. One was, become in the judiciary, and those are all success stories. Children deserve second chances. You never know what brought a child to that place. Judge Beecroft, he's another one who I met at one of the conferences, and he gave me a copy of his book. And he had a whole series of stories about children and that he encountered in his judicial practice. And some of the children had committed some crimes and they had turned their lives around, because you don't know what moves a child sometimes to commit a heinous crime. A number of things. And one of the stories I remember, another judge as well, there's one who, I don't know if you all have a program, Hot Bench, and he himself was also telling me about judging children as children, a proposal for juvenile justice in Michael Correiro. He gave me his book. You probably have to, he has a television program. And he tells stories about some of the children he's met in practice. And when he delved into their history, you see that they passed through some very trying experiences. And a number of them, heirs as well, who has written another book that I have here. And he spoke one day about a child who took a weapon and stabbed another child. And do you know, that child had witnessed her mother being stabbed to death and still had that anger in her that had not been resolved. And a number of children go through some experiences and we do not have sufficient counseling, maybe in terms of in length of time we counsel them, because we never have enough social workers, we never have enough psychologists. And when we do not repair that child, we cannot fix that child. Now, many children have good intervention in their lives. Sometimes one person in that child's life has turned that child around, and that child has become a model citizen. Because juvenile justice practitioners, as one of the things they told us in that Juvenile Justice Congress in Geneva, and there was another one in Paris, and one of the things, consistent stories is, we are merchants of hope. If you're involved in child justice, you must sell hope. As long as there is life, there is hope. I met a little boy, he was before the court. I looked at him, I couldn't believe he was 14 years old. And he was arrested for driving a car without a license. I said, but you can't even see above the dashboard, what are you doing driving? And I sat with him and he said, miss, I didn't pass my common entrance and I went to work in this garage. I was making money, and my stepfather, he used to take all my money. And I became angry and I went and I stole this car. I started representing him in court, and one day this man came out, director of the legal aid clinic at the law school in Trinidad. He came into my office and said, I'm taking over from now. His father was a police officer, but played no part in his child's life. And there are many, you see this father absence, This father absence is a serious problem. It is a serious problem. And we have to look at that. So we are really creating the criminals. Children at school are being abused emotionally, verbally, and physically. Even when we abolish corporal punishment, it is still happening. Children are subjected to all kinds of abuses. We just sentenced a woman who some years ago, a school principal, put 2 children's head in a toilet and flush it. Now imagine the anger of those children if those things are not attended to. And that's at a prestige primary school where children paying big fees. You have teachers who have thrown things at children into their eyes. Children are being turned into criminals. And then at the end of the day, we say, throw them on the dustbin heap. We have to fix the problem by looking at prevention, first of all. Respect and dignity for children. Some people believe children shouldn't be respected. Who are you? I make you, I can take you out. We have to do things better. So children who have committed a heinous crime, let's find out what happened to you. Not so much what you did. What happened to you to make you do that? There are few children who are sociopaths. And I want to tell you that the children who committed those things when they went into these California and the different places and shoot up schools, when you hear this story, everyone is a loner. And you know, we like to say, oh gosh, he nice and quiet, eh? Watch it. She nice and quiet, eh? Watch it. Find out why that child is not interacting. Every day, every teacher in every school should start with a restorative practice. Asking the child, tell me, what was your weekend like? What was your day like? Do a go around. Tell me about your day. Do not see children quiet and ignore. We have to get to find out what is happening. There was a child that every day in my class, I used to be a school teacher long before I became a lawyer. And I remember this child, she always quiet to say, stay back and let's talk. She said, Miss, my daddy say I'm not his child. My daddy say I'm a horn child because I fair skin and everybody else have black skin, miss. And miss, he just bring things home and he don't give me none, miss. He say I'm not a child. What? That child can't study. She's going through hell. Every day, every day. Now, if that child, she was very quiet. Some of them lash out at society. They want to hurt. You know that saying? Hurt people, hurting people. We have to find out, get behind that hurt. You'll be surprised. One teacher can make a big difference. One neighbor, one child, a colleague, somebody can make a difference in a child's life. Forgive me, I could go on and on with that passion, but I can tell you, you have a chance to make a difference if you get into child justice. Please, do not speak harshly to the children. Do not look at them as though they're no good, they're dirt. Care for them, love them. Love can work miracles.
Thank you, Senator Thompson. There are many more questions. Unfortunately, at this juncture, we will have to hold on that because of the timing and the other presenters who also need to make presentations. We are very appreciative of the presentation you've made to enlighten us on the juvenile justice reform throughout the Caribbean and the perspectives that have been presented. At this particular time, I just want to advise the participants that Minister Frankie Campbell extends his apologies as he has had to travel. We recognize the presence of Permanent Secretary Treasurer Ramming, who joined us for part of the presentations, and also note the presence of the minister's senior officers from the Department of Rehabilitative Welfare Services, Quinton Gray and Sonia Saunders, and other staff members who I'm told are also participating. Our next presenter will be presenting on the topic The Child Before the Court, the Juvenile Court of the Bahamas. Magistrate Cara Turnquest DeVoe completed her LLB studies at Holborn College, London, England, and thereafter was in the class of first graduates from the Eugene Depute Law School. Magistrate Turnquest DeVoe was admitted to the Bahamas Bar in October 2000 and completed pupillage at Evans & Co. with Mr. Thomas Evans QC, and remained at Evans & Co. as an associate counsel until establishing her own legal practice, Turnquest & Co. in 2003, with a focus on family and commercial matters. In October 2011, Magistrate Turnquest DeVoe was invited to sit as a stipendiary and circuit magistrate with responsibility for Eleuthera, and in March 2016, returned to Nassau and was assigned to the Juvenile Court in May 2016, and has remained since only briefly between February 2018 and August 2019, assigned to Court 11. She's married, the mother of 2 children, and of note to the animal lovers, this is very important, she has 3 cats and a dog. Without further ado, I introduce Magistrate Cara Turnquest DeVoe to make her presentation. Please welcome her.
Thank you, Mr. Carey. Good morning, everybody. It is indeed a pleasure and a privilege to return to my roots and also to deliver this presentation to you this morning. I've been asked to speak on the topic, the child before the court, the Juvenile Court of the Commonwealth of the Bahamas. Firstly, to give you a background on how the Juvenile Court in the Commonwealth of the Bahamas is constituted. I am the chairperson of the court. The magistrate sits as the chairperson. I sit along with a panel. The panel members are appointed after the minister, in consultation with the Chief Justice, selects the persons. We have nothing less than 6 persons. Currently, our list is at 20 persons, from which we select persons to sit on days that they are available. Our panel members are volunteers. They come from various walks of life, the Commonwealth of the Bahamas, and their role mainly is to assist the court with making decisions as to what is going to happen with the child who is before the court. And that is the child who is charged with a criminal offense. Panelists are between the ages of 25 and 65 years. The last panel that we had was a little bit older than this panel. And I think this panel may be one of the youngest panels that we have seen in a while. Now, firstly, when the juveniles come before the magistrate's court, which is court number 2 in New Providence, they always appear with a parent or guardian. That is important because, as you know, child is unfamiliar with what they're walking into. And it is hopeful that the parent, though we hope they're not too familiar with what the child is walking into, they would act as the child's advocate in some instances where the child does not have an attorney, and also to assist the child with questions that may be coming from the bench, which is myself as the chairperson reading the charge to them. Once a child is asked whether or not they admit or deny the charge, because the child is not asked, as in the court, if they're guilty or not guilty. If they admit the charge, the matter is then assigned to a probation officer. Now, at this point, I must let you all know that currently in the Commonwealth of the Bahamas, there are only 3 probation officers to assist with juvenile matters. We have 1 male, Mr. Angelo King, and we have 2 females, Ms. Sharon Brennan and Ms. Willan Mills. These 3 persons, I don't know how they do it, but they are being worked in order to get these reports prepared. The purpose of the report is to give the panel an insight into what is going on with the juvenile, the background as to how they got here, and their version of events, because unlike in the adult court, the panel doesn't know the story or the facts before that report is prepared and placed before the panel members. The juvenile is then asked or given an opportunity to express themselves as to what happened really. Some instances they're shy and it takes a while to get that information out of them. But once they open up, after a while, they open up, we get a feel as to who it is we're dealing with. And we know, where we're going in terms of what punishment, if any, juvenile should get based on the offense that they are before the court on. Now, our punishments, if we do decide to give punishments, can range anywhere from probation, community service hours, or detention at one of the mini spa and resorts, I call them, either the Willie Mae Pratt School for Girls or the Simpson Penn School for Boys. Once a child is given their marching orders, I call it, they're expected to meet with that probation officer to know the when, the where, and the how. They're expected to complete those community service hours, the terms of their probation. If they're assigned for counseling, that person, that probation officer, becomes their new best friend. They're given a date to return to court. We get an update as to what is happening with them. And sometimes if they're not following through with what they are expected to do, we usually ask them what's going on with them and try and see if we can help to steer them back to where they need to be. Oftentimes, the probation officer, catches that before they get back to court, so they steer them back in line. But we do have a few that take a walk on the wild side and try to test the system, so to speak. Those few ones that we do have, we may need to remove them from their environment, which we don't like to, because our little mini spa and resorts, we try to keep them as empty as possible. Currently at Simpson Penn, we have a number that fluctuates between 15 and 20 males. That number does not only include persons with matters before the courts, but also persons who are on care orders. At the Willie Mae Pratt School for Girls, the number earlier this month was at 11. Now, the reason why the numbers keep moving back and forth, persons get bail, persons age out, persons care orders, they are placed with family members. So the numbers are up and down, but we try to keep them as small as we can. Now, going back to the juvenile before the court, if the juvenile denies the charge, the matter is then fixed for trial. Currently, the juvenile court has 47 matters stemming from 2020 up to the beginning of this month that are set for trial. So those matters, hopefully, we are going to get started as early as next month, as soon as we work out a few internal issues that we have in the building. We can get started with hearing those matters. Once the matter is set for trial, the juvenile, along with the parent, is expected to ask questions of the witness. If they do not have an attorney, the court can intercede on their behalf and ask questions of the witness to help the juvenile along, as well as the parent. Now, once the matter is concluded, again, the panel sits with the magistrate the entire time of the trial, and the same panel that starts that trial has to see that trial through to the end, because they're familiar with the evidence being led, so that they would make a better decision as to what would happen with the juvenile on conclusion of the trial in terms of penalties, if any. Sometimes matters are dismissed. Juveniles are not given any punishment. They're just given a caution. You talk to them, find out what it is they want to do once they finish school, what it is they're doing now, and based on what they say, panel members and myself in the past would have directed them in certain areas to keep them moving forward. In addition to the trials, the updates on matters before the court, every week I'm expected to see juveniles on remand. Because of COVID, that's been proven a bit challenging. However, before COVID, I would ask the juveniles, I would say to them, if it is something that they wanted to share, something that's happening with them, they can let me know. And because I have to come down to their level, we've developed a different way of speaking, communicating with each other. So I would say to them, if there's anything they want to say to me, they can just say they need to speak to me off air. What that means is that they don't want any of the other prosecutors, any attorneys, or any of the persons from the various homes that would have escorted them to be in the room at the time. So that's their time to share with me what's actually going on with them. And based on what they tell me, I then move to do certain things on their behalf to investigate what it is they're saying and also to assist them with resolving whatever issues it is that they have. I do that with all of the juveniles, even the ones before the courts. So I've developed a relationship with them in terms of, them feeling a little bit more at ease when they come to court. But on the flip side of that, when they do come before the court, I say to them, if they have curfew, they have to be indoors by a certain time, that I expect them to be indoors, because I don't rely on the police officers or the probation officers to tell me that they're out. It always happens that I'm the one that catches them out after hours. And so I wait for their next court date, at which time we speak off air as to why it is that they're out. But in addition to that, we are hopeful that, we can get these matters moving as quickly as possible. And I don't know if anybody has any questions for me, but.
Thank you, Magistrate Turnquist DeVoe. I'm sure there are some questions coming in our Q&A box shortly. In terms of your experience as a magistrate in juvenile justice, this is my question to you as moderator. What advice would you give to future lawyers and newly qualified lawyers as to developing a pathway and career and being able to make an impact in this area?
I think attorneys coming in ought to familiarize themselves firstly with the law as it relates to the juveniles, because a lot of attorneys, because they've done a lot of criminal work with adults, they're not with the peculiarities that follow the juvenile through the criminal justice system in the Bahamas. That's the first thing that they ought to do. Secondly, they ought to look at ways that we can reform the current system, and that is familiarizing themselves with all of the stakeholders. And in addition to that, they really need to have a background in child care or child welfare, because a lot of persons don't talk to children, they talk at children. And that is where a lot of persons miss everything when it comes to dealing with children. At least that has been my experience.
Okay, thank you. There are a couple more questions that have come in. One from Kashina Thompson. Do you think that the limited number of probation officers can possibly affect the juveniles' access to justice? The first part of it. The second part, are provisions being made to increase the number of probation officers in the Bahamas?
I think the limited number of probation officers does affect the juveniles, but to their credit, I must say, the 3 officers that are there now, they are, I can't tell you how grateful I am for those 3 that are there. We have 1 male, Mr. Angelo King. We have Ms. Brennan, Sharon Brennan, and we have Ms. Willan Mills. Those 3 have carried the load even before COVID. Because of Dorian, those 3 have carried the load throughout. We've lost a number of good probation officers. We've lost, Mr. Fraser has moved on. Ms. Wendon Miller has moved on, but we've also lost Mr. Taylor. We've lost Mr. Boyd. We've lost Ms. Saunders. Ms. Saunders is at the Simpson Penn School for Boys. But whilst we appreciate her impact there, we really could use a few more of her and a few more Mr. Kings. But I don't know, I can't speak to whether or not they can get the additional probation officers, because I think they first need to look at that issue of salary. They may need to make it more inviting to the persons to come on board, because these persons are actually putting themselves at risk going into these. Some of these communities are very rough in the Bahamas, and we are actually putting these persons, they're going in their personal vehicles, they're going by themselves, just to get the job done. So there are a lot of things that need to be taken into consideration in terms of probation officers. But I appreciate the ones that we do have now.
Okay, thank you very much. There are a couple more questions coming in. If you're willing to take more, we can ask more. There's a question from Lillian Webbers. Greetings from Suriname. Do you know how many social workers are there in the correctional facilities, and do they practice case management?
I do not know how many social workers there are in total at the correctional facilities. I do know one who we lost, that's Mr. Taylor. I'm not sure what programs the Bahamas Department of Corrections has in place in terms of the schools, the Willie Mae Pratt School for Girls. There are social workers assigned, and there is also a social worker assigned to Simpson Penn. So because the numbers are continuously moving, to give you an exact number as to who is at what facility, I honestly cannot say right now. The best person for that would be the minister.
Okay, thank you very much. I have a couple more questions. A child is present before the court, and this is an anonymous question, so the person hasn't stated their name. A child is present before the courts on the family islands for beyond parental control. What provisions are set in place for the parent, as there is no national parenting program on the island?
Well, I have the responsibility for Eleuthera, and I'm sure the same obtains to all of the other islands. The social workers on the island, they do assist the parents in terms of a parenting program. So that would be more one-on-one with the particular parent or parents, because that person is correct. I don't know that there is an official program set up, because the numbers coming out of the family island is a whole lot less than it is in New Providence. So the social worker ordinarily sits with the parent or parent and takes them through the program that is established, has been established by the National Parenting Program. It would help to know which island they're speaking about.
Unfortunately, they placed an anonymous and did not give the information there. Thank you very much for your answer there. Another question that's put by Sharon Smith. Do you see the same juveniles coming before the courts? And if you do, what punishment is given? Not quite sure how to approach that, but
I used to see the same juveniles coming. The punishment goes along with the offense. Remember now, we are given a social inquiry report that includes that particular juvenile's version of events as to what transpired to cause them to be before the court again. Now, we've had some juveniles who we can see are escalating. When I say escalating, offense is getting more serious each time. So when we see that the offense is getting more serious each time, so they may come in for unlawfully carrying arms, some may come in for assault, then we see they step up to causing harm, major causing harm and grievous harm. When we see them escalating, the recommendation usually is that they be given, I call it a timeout, which is being held at one of the facilities for a period of time so that they can see the importance of being free versus being detained at a facility. This would have been after they would have been given counseling based on what we find out was going on with this juvenile that would have brought them into the system in the first place. So it would be after we would have tried a number of things that we take them on now into one of the facilities.
Okay, thank you. Another question from Anne-Marie Albury. Are juvenile panelists trained for their responsibilities in the court? Is the Bahamas looking to designate specific courts for juvenile matters?
And let me answer it from the end of the question back to the front. Currently, there are only 3 islands where the panel sits. That is New Providence, Abaco, and Grand Bahama. No other island has panel. Those are the only 3 islands that have the panels. As it relates to panel members, the panel members would have submitted to the Department of Social Services their qualifications in terms of their exposure to assisting juveniles or their work with juveniles. So as it relates to training, I can't say that there is a specific training program offered by the Department of Social Services. There may be, but I'm not aware of a specific training program per se.
Okay, thank you. Another question from Anna Hasty. In cases where it is found that a parent or adult or other adult is culpable, 1, will the adults be charged? 2, will the child be protected from those adults?
Oh, we have that all the time. We have children being charged along with adults on a regular basis, because for the persons in New Providence, you must know that the trend now is persons committing offenses seem to be taking juveniles along with them, particularly where those offenses involve a firearm, and the juvenile is given that firearm once they're stopped by the police and told to say, that is your weapon. And I can tell based on the person appearing before me that they are clueless as to why they're there and what's happening. But that is trending now in the Bahamas, where a juvenile is taken along with the adult. What is happening is the adults and the child will be all charged together. Once the persons, once they've been arraigned, if the adults deny the charge, they go one way to a court and the juvenile comes over to me. Whether or not the juvenile admits or denies the charge, we try our best to find out what really happened to cause them to be where they are.
Okay, thank you for that. Magistrate, another question from Angel Bevins. Are there probation officers for other islands such as Grand Bahama, Andros, or any other family islands?
In terms of Grand Bahama, they have probation officers. Abaco has probation officers as well. As it relates to the other family islands, because the numbers are so small, in terms of juveniles appearing before the court, there are no probation officers per se. So the social worker who is assigned to that particular area of whichever island it is will act as the probation officer for the child before the court.
Okay, another question from Sandra Patterson. Has there been consideration given to using restorative justice to help juveniles understand the impact of their offense?
When the juveniles appear, oftentimes once they are sent off for counseling sessions, it depends on the offense and what we learn from the juvenile. When I say we, I'm talking about what the probation officer gleans from the interviews held with the child and the parent and the other family members. It depends on what is gleaned from those interviews. The juvenile is steered towards the various counselors that provide them with the assistance that they need. Those that are repeat offenders, we try our best with them, and the short answer would be yes, but I don't know that we are fully there as yet.
Okay, we have two more questions, given your time and the schedule as well. The second to last question: are you as magistrate liaising with other departments such as social services or other areas to try to prevent juveniles from entering the system from the beginning?
Short answer, no. There has been a disconnect between all of the agencies for a while. Not that we have not tried, but because there's been a disconnect between the various agencies, between the police and the Department of Social Services, the Department of Social Services and the court, those areas of the Department of Social Services, I should say, because there's been a disconnect, we have not been able to get that done, make that happen. So that is the honest, short answer I can give.
Thank you. And the final question from Rayshawn Delaveau: has there been any counseling provisions put in place for juveniles either during or after their hearing?
For juveniles that would have admitted the charge before the court, they are given counseling, depending, again, it depends on what is gleaned from the interview, the type of counseling they receive. Oftentimes, some of the juveniles are known to the Department of Social Services prior to committing an offense. Those numbers are small, but those persons would have received counseling if, after interviewing the juvenile and the parents, the social worker determines that they need some counseling or need to be evaluated. They would go on to be evaluated and receive that counseling. We are always surprised when we see those persons coming before the court, charged with a criminal offense. After they would have completed matters before the court, that option is available to them. I don't know that very many of them continue on after they're finished with court, because they're often happy for the males to divorce me and for the girls to no longer be my best friends. So once they're done with court, they're gone.
Magistrate Turnquest DeVoe, thank you very much for your insightful presentation on this very important subject that criminal legal clinic in particular has been focused on during the last couple of months. And it's very insightful for all the participants on the child before the court, the juvenile court of the Bahamas, and your experience and insights to us.
Thank you.
At this time, we are going to transition into a panel discussion. And that panel discussion is titled "The Child in the Care of the State, a Critical Examination." My role is to introduce the moderator for that panel discussion, which will continue to add significant value to the discussions that have been had already for the morning for us. Our moderator for this discussion is Mr. Darren Turnquest, a Bahamian native, celebrated for his distinct ability to inspire, motivate, cultivate, and drive the change process. An accomplished counseling psychologist, public speaker, youth development specialist, and corporate trainer, Mr. Turnquest has proven his ability to galvanize individual communities, institutions, organizations to be the change we want to see. In 2005, Mr. Turnquest received his Bachelor of Science in Psychology with a minor in Political Science from Arcadia University in Nova Scotia, Canada. And in 2007, he earned a MA, Master of Arts in Psychology from Anna Maria College in Paxton, Massachusetts. While pursuing his master's degree, Mr. Turnquest worked at numerous institutions in Boston. After completing his degree and work term in Massachusetts, Mr. Turnquest followed his dream of wanting to return to the Bahamas. No stranger to hard work, and with a strong commitment to service, upon his return home, he served as a counseling psychologist at the Bahamas Crisis Center and as the director of residential planning at the Bahamas Institute of Adolescent and Child Mental Health. In 2007, Mr. Turnquest served in dual capacity as a psychologist and classroom teacher in St. Andrews in Nassau. In 2011, he was appointed by the Bahamas Public Service Commission as the youngest person to serve as a director. And since 2011, he served as a director of youth within the Ministry of Youth, Sports, and Culture. Among these responsibilities, Turnquest was selected as the national co-chair for Volunteer Bahamas. In 2012, Mr. Turnquest served Dean of the CARICOM Secretariat Technical Resource Network on Youth Affairs, where he completed his term in 2000. In September 2017, Mr. Turnquest was promoted to the position of Deputy Permanent Secretary in the Ministry of Youth, Sports, and Culture until his resignation in 2019. He has held substantial and numerous executive leadership roles within the private sector. It's my pleasure to introduce and present to the participants who are watching the webinar, Mr. K. Darren Turnquest, who is the orator, and who will also introduce panelists for the next segment.
Thank you very much, John. And of course, to our distinguished speakers who would have been ahead of us, we now reach the second segment, which I imagine, based on the speakers that I see in this panel, is going to be extremely hot and provocative, in the words of one of our famous radio hosts in the country. Colleagues, it's always wonderful to see 138 attendees and of course 10 panelists who are putting the affairs of young people at the forefront. I am so happy to have seen Hazel Thompson-Ayi and of course Magistrate Turnquest DeVoe, who I have been able to read the work, and in the case of Magistrate Turnquest, I've been able to see her work in action, although I'm dreadfully fearful of the courts. The child in the care of the state, a critical examination. Today we have three panelists. We have Dr. Chaswell Hanna, we have Ms. Jenna Christie, and of course, Tavari Smith. As we have maneuvered through what feels like forever in this pandemic, we have talked so much about jobs, education, tourism, domestic violence, and a list of other critical challenges. To date, we have considered every economic challenge and many of the traditional social challenges. However, have we considered the impact that these times have had on young people, in particular, those in state care? The most traumatic experience I've witnessed as a psychologist is for a child when they have been pulled away from their families and placed in state care. And one of the most depressing feelings is a child who simply have no family and are left in state care. Many of our children are faced with these challenges of the court system, juvenile correction facilities, group homes, and foster care. How have we supported them, protected them, engaged them, and advocated for them? In 20 years, what have we done to shake the system up? The latest social media buzz has focused our attention on just one incident. And the question is, are there more to come forward? Is this the order of the day? Or is this something that has been separated or sensationalized by our media moguls? Rita F. Pearson says, every child deserves a champion, an adult who will never give up on them, who understands the power of connection and insists that they become the best they can possibly be. Are we making the best possible for our kids in state care? Have we found our compassion, in the words of a famous person in our country? Do we in fact have a heart? Who is and who will be the champion moving forward? Do we have the legislation and the resources to make it better? Our speakers each will have about 12 to 15 minutes to speak. I will introduce our speakers now. Once the speaker has completed, I will then go on to the second speaker and then the third, and then we will open for questions. To my colleagues who are in the cabin, as our moderator had said earlier in the morning, we ask that you just simply put your questions in the chat and I will make sure to take note of them. Our first presenter, Dr. Chaswell Hanna. Dr. Chaswell Hanna began his policing career in 1993 and has held numerous degrees, namely a master's degree in criminal justice and law enforcement and a doctor of education degree in organization leadership and conflict resolution. Dr. Hanna spent his initial years on the force of the Central Detective Unit, and between 2007 and 2009, he was appointed as the officer in charge of the force's research and planning unit. Dr. Hanna also serves as adjunct lecturer at the University of the Bahamas and also lectured at Nova Southeastern University in criminology, criminal justice, sociology, and leadership, and also a professional author who has penned many books. In 2014, Dr. Hannah was seconded to the Ministry of National Security as the director of the National Anti-Drug Secretariat. In 2016, Dr. Hannah completed a 3-month attachment with the Atlanta Police Department under the executive leadership program of Georgia's International Law Enforcement Exchange in Georgia, USA. In February 2018, Dr. Hannah was appointed as the National Commandant of Training for the Force. During this time, there he coordinated the establishment of many key programs. And when I looked at his CV, namely the one that stuck out for today was the institution of the Police Cadet Program. In October 2019, he received a Global Law Enforcement honor to serve as a member of the Community Policing Committee for the International Association of Chiefs of Police. In 2020, he was appointed as Deputy Commander of the Northeastern Division, and in January of 2021, he was appointed as the officer in charge of the Western Division. He is married with a son and 2 daughters. Ladies and gentlemen, help me welcome Dr. Chaswell Hannah. Dr. Hannah, over to you. If you're having a slight issue connecting, Dr. Hannah, if you can just send a message in the chat.
Thank you so much. Can you hear me now?
Okay, I can hear you very well.
Good morning. Thank you so much. Thank you, Mr. Moderator. And let me just start off by saying good morning to each of you, the distinguished panelists, and all of our participants who are tuning in to this webinar. Let me just say that on behalf of our Commissioner of Police, Mr. Paul Rule, it is a great honor for me to be sharing with you on this topic, juveniles and the law, the juvenile justice system in the Bahamas, and in particular this panel that deals with the child in the care of the state, a critical examination. And my particular short presentation will be on the child in the hands of the police. I'm going to go ahead and begin to share my screen as I have a PowerPoint presentation. And can somebody confirm if they're able to see the PowerPoint screen? Excellent. Okay. 1 second while I cue this up. Okay, so the Royal Bahamas Police Force, let me say at the outset, is very supportive of the welfare and overall well-being of the child, whether they be a witness, a victim, or a suspect in a criminal matter. That is the main focus. Our main focus is the welfare and well-being of the child. Now, before I talk about more details about how our policies and procedures handle juveniles, I just want to cite a few statistics related to juveniles in the criminal justice system here in the Bahamas. And I conducted a study on murders between 2010 and 2015. And I pulled out this chart, and this is the number of murder victims over that 6-year period. And as you can see, of homicide, 27 between the age of 0 and 17, represents a very negligible number of arson to the more dominant age groups of 18 to 25, which represents 200. Or the 26 to 35 age range, which represents 228. The next, and again, during that time period of the murder suspects being under the age of 18, 14 in particular, the most dominant group being between the age of 18 and 25. So we see that juveniles play a very small role insofar as murder victims and suspects. Let's look at the juvenile and drug offenses, okay? This is the drug stats for the entire year of 2020. And again, we see that juveniles, again, while they're present, they make up a very small number of persons who commit drug offenses. Out of the 1,383 persons arrested for drug offenses, only 263 of them were juveniles. Out of the 1,120 charged, 25 were juveniles. And there were 17 juveniles in the group that were not charged. And that is for the entire year of 2020. Now, in terms of our policy approach, as I opened up and said earlier, the child's safety and welfare, whether they are a victim, a witness, or a suspect, is always a top priority for the Royal Bahamas Police Force. And our policies and procedures support this position. And in fact, in our standing operating procedures, we cite articles out of the Constitution. First, Article 17, which speaks to the protection from inhumane treatment. No person shall be subjected to torture or to inhumane or degrading treatment or punishment. So we put that out at the outset to make sure that everybody who comes in contact with the police are treated with human and upstanding treatment. We don't support anything less. I want to say that very clearly up front. Also in Article 19 of the Constitution, which speaks to the protection of persons from arbitrary arrest and detention, okay? And subsection 3 speaks to, in the case of a person under the age of 18 years, to be afforded reasonable opportunity for communication with their parent and guardian. So in the case of arrest, when we arrest a juvenile, immediately they will have an opportunity to speak to their parent and guardian. In fact, we make that item number 1. When we have a juvenile in custody, we want to get a hold of this child's parent or guardian immediately and make them aware that their child were arrested, top priority. And we also do our best to explain to the child at the time their reason for being in police custody. And we do it again once we get a hold of the parent. Then we have something called judges' rules and administrative directions to the police, which also go a little deeper into our policies and procedures. And in section 20 of that policy, it speaks to the fact that if a person in custody is under the age of 18 years or is mentally handicapped or suffering from any mental illness, the station officer must, as soon as possible, inform an appropriate adult of the grounds for his or her detention and his whereabouts, and ask the adult to visit the police station to see that detained person. Okay? Also in section 22 of that policy, we define what an appropriate adult is. And in the case of a person under the years of 18, under 18 years, their parent or legal guardian, a social worker, or failing either of the above, another reasonable adult who is not a police officer or employed by the police. So when we can't get the parent or legal guardian or social worker, we will reach out to perhaps a nurse, a pastor, or a youth worker. But we definitely make an effort to have an appropriate adult in on the front end of that arrest. Also, when a juvenile is arrested, we're careful not to place juveniles in a cell with other suspects. Okay, so if there's a juvenile in custody, they'll be in a cell by themselves. In fact, the policy also speaks to the fact that we really try not to put a juvenile in a cell if there is another suitable place for the juvenile to wait or be dealt with in the station. So there may be an interview room that may be available where we'll put the juvenile. But in cases of security for protection of the juvenile, a cell may be appropriate. But if we make that decision, they will definitely be in a cell by themselves. They would not be in a cell with adults. Okay. Then Section 70 of that policy, our arrest and detention policy, speaks to interviews with juveniles. Okay, can only take place in the presence of an appropriate adult, which was defined earlier in Section 20. Okay. In the case of juveniles, if we make a decision to charge, and again, let me just say, charging really we look at as the last resort. We look at the nature of the offense. Perhaps it may be more appropriate to deal with a juvenile outside of the criminal justice, but with some level of formal sanction. And we try to do that whenever appropriate. But when not appropriate, if it is appropriate for a juvenile to be charged with an offense, we want to make sure that it is clearly appropriate. Considerable discretion is given to the station officer in relation to juveniles who, other than certain circumstances, should not be charged. Other methods of dealing with the juvenile without involving a court appearance, there may be more appropriate. And so we try to do that as much as possible. Sometimes there may be a matter where we could call in the parent and sit down with the victims or the complainant and try to work out a resolution. Sometimes a warning may be more appropriate. Sometimes some of these kids may need a positive role model to speak with them. But again, that is only in those appropriate circumstances. And then when we look at bail, if somebody is charged, we try to, where appropriate, give that child police bail. Rather than having them sleep in the police station in a cell overnight, we release them to the custody of their parent or guardian or an appropriate person who will ensure that they will appear in court. And only in extreme circumstances, for the protection of that juvenile, we would recommend that the child's continued detention be continued. And that's only in the interest of the welfare. So as you can see through our policies, and these are carefully outlined in our 4 standing orders, we make sure that when a juvenile comes into police custody, we want to make sure that they are swiftly dealt with in the most appropriate manner in front of their parents, guardians, and where appropriate, we try to deal with the matter outside of the criminal justice system where appropriate. And again, I stress where appropriate. And as I begin to wrap up, I want to just let all of the viewers know that the Royal Bahamas Police Force has many partnerships with juvenile groups that promote safety and protection of juveniles. One such is the National Neighborhood Watch Council under the Ministry of National Security, where we have liaison officers in all of our divisions who partner with children and young persons and deal with their public safety concerns and try to be that bridge that gap between the police and the youths and see where we could assist these youths in following the law. We also have school liaison officers at our schools that work in the schools with the school administrators, the principals, vice principals, and headmasters and mistresses to see those at-risk youth. They may need some counseling, some advice. We come into the schools. We speak to them on a regular basis to try and promote safety. We also have sections that, again, work with youth groups, juvenile groups, and young people. And there's also officers attached who are out there in communities trying to identify youths at risk where we can intervene and keep them out of the criminal justice system on the front end. Also, with the NNWC, there's another very useful program keeping youths and juveniles positively engaged, and that's with the marching band. This photo here is with the Mount Moriah Marching Band out of our South Central Division. And a number of these kids end up getting scholarships for university to attend by playing these musical instruments. So the police, again, very much involved in trying to prevent or lower the number of juveniles who come into the criminal justice system. And we believe if we get them on the front end, we'll be in a better position rather than those who come in. And as I conclude, we're also supportive in the police force of a number of strategies to reduce juvenile delinquency. When I was the director of NADS, the National Anti-Drug Secretariat within the Ministry of National Security, we had a program we launched, I'm Loving Me Drug Free, where we took a public health approach to drug prevention. And there was national drug prevalence surveys conducted in schools. And the results indicated that, our level of drug use among juveniles in schools fall below the regional average, which is good news. But obviously, we want to lower the number as much as possible. And also, when I was in office, and I think this is something that's still in communication that we're still exploring, is the establishment of a drug treatment court. Where you have what we call therapeutic jurisprudence, where a child rather sentenced or being caught with a small amount of marijuana, rather than facing punitive sanctions, will go to a treatment center. And so those are some of the items we support in the police force to try and lower the number of juveniles who come in the criminal justice system on the front end. The police, we are the gatekeepers of the criminal justice system, controlling the number who actually come in. And finally, increased educational achievement. We believe that kids who have a higher level of educational attainment will reduce their likelihood of becoming involved in criminal behavior. So we're supportive of a revision of educational policies and laws on discipline, expansion of technical and vocational subject options, establishing special schools for students with behavioral challenges, and also capacity building in educational programs at the Bahamas Department of Correctional Services. And so with that, I hand back over to the moderator, and I will end as I began. The Royal Bahamas Police Force is committed to ensuring that the welfare of the juvenile, when they come in contact with police, is paramount. It is our top priority. And thank you so much, and I hand back over to the distinguished moderator.
Thank you so much, Anna. And I would ask colleagues to just please place your questions into the Q&A box, and we will come to those questions at the end of our speaker's presentation. Our next speaker, a fearless advocate for young people and a woman who's always in the business of getting the job done. Ms. Jenna Christie is a highly dedicated mental health therapist trained in formulating and implementing psychosocial treatment plans for individual and group clients of all ages. A true nationalist with extensive training, Ms. Christie holds a bachelor's degree in psychology, a master's of social work, master's of couple and family therapy, and is currently pursuing a doctorate of education in, organizational leadership. She's received specialized training in many areas, namely acute stress syndrome and stabilization, called the ASSIST for groups and individuals, human trafficking, child safeguarding, trauma-focused cognitive behavioral therapy, motivational interviewing. While a true academic, Ms. Christie is known for her passion for the field. Jen has consulted for numerous crisis centers across the United States, and once returning home, her work in mental health did not stop. Upon her return, Ms. Christie has worked at the Department of Social Services and supported other key mental health initiatives and organizations in country. In 2020, Ms. Christie decided to switch her focus and place greater emphasis into her private practice and explore new options. Today, Ms. Christie serves as the principal therapist at the Grand Bahama Children's Home. Jenna has also served as the mental health facilitator at the National Art Gallery of the Bahamas We Gotcha program, supporting victims of Hurricane Dorian, chairman of the National Association for Juvenile Advocacy, board member currently at the Bahamas Alzheimer's Association, and Bahamas State Domestic Violence Coordinator for Zeta Phi Beta Sorority Incorporated. Ladies and gentlemen, a personal friend of mine that I've seen inside the highways and byways of juvenile justice, help me welcome Ms. Jenna Christie. Jenna, you can take it away.
Thank you. Thank you so much, Darren. Good day, and thank you all for having me here as the panelist to speak on the child in the care of government facilities. In order for a child to be housed in a government facility, there must be a valid care order in place. I don't believe we covered exactly what that is, but it is a legal document that places a child in the care of approved foster parents, an approved children's home, a juvenile correctional facility, such as Willie Mae Pratt Center for Girls or Simpson Penn Center for Boys, a treatment facility such as Sandlands Rehabilitation Center, or with an approved guardian. Before we could really discuss the rights of the child in these establishments, it is important to understand the available facilities and the differences between them. Now, this is not to say that the basic rights of the child vary from facility to facility, but knowing the intended purposes or operational variations can be very beneficial and can prevent unintended additional harm. Out-of-home placement is supposed to be the last resort unless the situation is so severe that it requires immediate intervention. The approved homes presently are Grand Bahama Children's Home, Elizabeth Estates Children's Home, Ranfilly Homes for Children, the Emergency Hostel, the Nazareth Center, and the home in Cat Island. These are the more standard homes for placement. But we also have Billany Lane, home that primarily houses children with special needs. And separate and apart from those homes, we have the juvenile detention facilities. Now, Willie Mae Pratt Center for Girls and Simpson Penn Center for Boys are facilities that are significantly different because they are intended to be a place of reform and rehabilitation for deviant and adverse behavior, as well as detainment for criminal matters. It's imperative that social service officers who are working with the children understand the differences between the different homes, because you want to ensure that when you are committing a child to one of these centers, that they are meeting the criteria of the intended population. So that's a basic overview of the available government facilities. Now, within these facilities, every child has certain rights. One of the rights is that they can remain in contact with their family members, but as the workers, we have the responsibility to protect them and preserve their best interests. So government residential facility placement is intended to be a short-term, not long-term placement. The goal is either reunification with family or to acquire other suitable living accommodations. Therefore, the children have a right to maintain contact with their family, except for in situations where it is proved to be detrimental to the best interest of the child. You do have certain situations where some parents just continue to provide toxic attachment styles that interfere with the child's development. So we try to limit their interaction with the children as much as possible to make sure that we are acting within their best interest. You have to have their physical, educational, and emotional needs also met. Now, the physical needs is inclusive of proper nutrition, adequate medical care, and even proper motor development. That's something that we sometimes do not think of, but when you have the approved children's homes and you have babies in those homes, you have infants and toddlers, you want to make sure that their motor skills are possibly being developed, properly developed, because we are the parents in this case. Educationally speaking, it is mandatory that children under the age of 16 receive their formal education. Now, once a child has attained 16 years, that doesn't mean that they automatically stop going to school. But the law does speak to the continued enrollment in a constructive educational system, whether that be regular secondary education or trade school. Part of meeting the educational needs of the children also means that we find necessary alternative educational options for children. Because once they enter into Willie Mae Pratt Center for Girls or Simpson Penn Center for Boys, they do still continue with their education. However, we know that there are differing abilities and some persons may not be as quote unquote book smart, but they work well with their hands. So you want to be able to foster those abilities and give them the appropriate support that they need. Emotional needs is probably one of the most understated and overlooked when it comes to our juveniles. Most of the children in the homes or the centers have experienced some form of trauma, which have led to their placement outside of their home. Now, whether they experienced it firsthand or witnessed it happening to another person, post-traumatic stress disorder is real and it significantly impacts our children's functioning and their overall well-being. In fact, many kids are suffering from complex trauma, which refers to the exposure to multiple traumas and the subsequent mental and emotional effects on top of that with other mental health concerns. It is estimated that anywhere from 50 to 75% of the children within the juvenile justice systems meet the criteria for mental health disorder. Anywhere from 40 to 80% of those who are already immersed in the system have at least one diagnosable mental health disorder. Some of the most prevalent are depression, anxiety, conduct disorders, substance abuse, and mood disorders. Juveniles with mood disorders such as depression, they are more likely to display adverse behavior. One of the symptoms of depression is characterized as irritable mood, which can increase the likelihood of aggression, especially during conflicts, as well as increases the risk of self-harm. So when you have a child who is experiencing a mood disorder, maybe they're showing certain behaviors while they're in school, because of their irritability and their inability to properly regulate their emotions when they engage in conflicts, they are more likely to be detained following the conflict than a child that does not have these certain disorders and displaying these types of behaviors on a more regular basis. Post-traumatic stress disorder and anxiety together can produce unexpected aggression in certain situations. Similarly, those with conduct disorders, that would be oppositional defiant disorder, they actually have an increased rate of repeat offending. The incidence of reoffending increases even more when there is a comorbidity, meaning that the child has one or more disorders that presently exist that they're battling with. This is why mental health counseling is so imperative to their healing and their ability to live a healthy life after experiencing their abuse and/or neglect and removal from their home. We often don't acknowledge the emotional impact that accompanies out-of-home placement into a government facility. We tend to think that when it's a situation of a child entering one of the standard homes, we say that they should be happy that they are no longer in what is a distressful situation. However, because they may not fully have an understanding as to what it is they're experiencing, their sense of security is broken and they're afraid and they are confused. Sometimes they may even miss their perpetrator and they don't even know how to properly articulate what it is that they're feeling. So because of it, it is displayed through their behavior, through the aggression, extreme moodiness. Some kids may even bring their behaviors that were modeled in their family home into the children's home. And without this understanding of these factors, it's sometimes perceived that the child is rude or the child is acting out. And that's where it becomes the impression that corporal punishment could be an appropriate intervention when we know that is not the case. So some ways that we can ensure that we take care of the emotional needs is that we provide proper counseling to these children. They receive it on the outside before they come into the detention centers. However, being able to continue with that has proven to be a rather stressful issue because we have laws that state that the workers who bring them to the home are supposed to continue following up with the cases. However, that's not always feasible with you only have, like Magistrate Turnquest DeVoe said, when you only have 3 workers, when you have very limited staff. And then you also have the factor that the worker whom they are attached to is located off-site. So when they're located off-site, it makes it even harder for them to get to the child. The workers who are present in the homes, the social workers who are there, one for Simpson Pen and one for Willie Mae Pratt, they are now also faced with dual roles because they are the ones to write the reports that go to the court to determine if they are being discharged or if they're granted an extension because more work is needed. But then they're also the ones who are expected to conduct the psychotherapy interventions. So it makes it difficult because now the child may not feel that they are getting the most out of what that worker can offer. They may not want to disclose certain information out of fear that it can be used against them. So collectively, we have a system that is full of barriers that prohibits our workers from being able to properly fulfill their duties and their responsibilities to the children in these facilities. Our care providers also need to be trained to understand the behaviors that they are witnessing. We charge them with the task of caring for the wards of the state, but it is the state's responsibility to ensure that they train them accordingly to handle the certain behaviors and to handle the mental issues that they see. Once you have taught differently, they can respond differently. And when a child displays negative behavior in an approved children's home, one of the first responses is typically to threaten to send them to one of these facilities. However, a majority of these cases, these non-criminal cases, can be resolved prior to detainment. So one of the biggest takeaways that I want you to take from this presentation about the children in the government facilities is that the children's homes are not meant to be a place where the children come and they sit and be fed, wait to be collected by a guardian, or wait out their sentence. It is supposed to be a place where we can stimulate their minds and challenge negative thinking, teach them to replace negative behaviors with positive ones, provide trauma counseling, and give them the specialized interventions that they need. But in order for that to happen, in order for us to give them the best quality of life, we need to re-examine our approach, re-examine our focus, and then reallocate our funds and our resources to a more proactive process than a reactive process.
Thank you so much, Jenna. I hear the passion in both Dr. Hannah and Jenna's voice. It means that we need to have more of these discussions, but of course, we also need to have more incredible action as it relates to our young people. Our next speaker is definitely no stranger to me and no stranger to anybody that's seen the juvenile justice landscape in the Bahamas. Mr. Tavares Smith is a young man who exudes passion, dedication, and pure activism. Known to many in the courts as the lawyer for juveniles and the one who's quick to save any young person who he comes into interaction with, through his youth advocacy, Mr. Smith has made many cringe at what some may call his pit bull approach to secure the rights of any child or youth at all costs. His partners at Bostwick and Bostwick have been baptized by fire in the field of juvenile justice and are now key advocates in the area and have done major pro bono work in the field. Mr. Smith holds an Associate of Law degree, a Bachelor of Law degree, Certificate of Legal Education from Eugene DePuy Law School, and numerous specializations, too numerous to mention. A known youth advocate, policy advisor, and Bahamian attorney, Mr. Smith has done extensive research and has represented both the Bahamas and the Caribbean on numerous panels and think tanks on juvenile justice reform and child rights. His work in the youth sector is known as being policy-driven with pragmatic actions. No stranger to advocacy, he and his team were successful in writing and driving the first ever national youth policy of the Bahamas, which was approved by the Cabinet of the Bahamas. Through his work, he has represented the Bahamas on numerous occasions at the United Nations and has worked closely with the Embassy of the United States in the Bahamas to continue his work in juvenile justice. His chief goal is always to advance the rights of youth and to allow common sense and a rights-based approach to prevail in the thinking and best practices when reforming any juvenile justice system or when having a conversation about a juvenile. Mr. Smith founded Project Youth Justice in 2013 and Youth Justice Caribbean Network in 2018, and works tirelessly to educate and bring awareness to local stakeholders and his regional counterparts. He currently serves as chairman for the Youth Advocacy Reform Committee and has been appointed to review and propose diversion and alternative dispute resolutions to the Chief Justice of the Bahamas. Ladies and gentlemen, the competent Tavares Smith.
Good afternoon, everybody. I think you can hear me now.
We can hear you.
Perfect. All right, so I have a brief PowerPoint. It's just about 4 slides that I'm going to go through very quickly, and then we'll take it from there, because I'm much more interested in hearing the discussions and the questions that will come forward. So let me get this up. I think you're seeing my screen now.
We are not seeing a document though. Ah, there you go.
Okay, perfect. Okay, so good afternoon, everybody. Senator the Honorable Hazel Thompson-Ahi. I refer to as Mama Hazel, Madam Principal, Senior Tutor, Director of the Legal Aid Clinic, faculty, staff, and students of the Eugene Depuch Law School, distinguished fellow panelists and presenters, Mr. Moderators, members of the viewing public, local and abroad, who are attending this webinar series. Good afternoon. I would first like to begin by thanking the organizers for granting me a few minutes to speak on a topic that is very dear and near to my heart, and one that has formed a considerable chunk of my practice over the past 8 years, and that is juvenile justice. I especially want to thank Bostwick & Bostwick, the law firm that I work with, who allows me to do this kind of work. I vividly recall my time as a second-year law school student at the Eugene Depuch Law School, while completing my in-service training for retired Justice Rhonda Bain, where I first encountered the unique and vulnerable challenges that court-involved young people tend to face. Though hers was a civil matter, I was present when Justice Bain cleared the courtroom to privately interview a child of tender age concerning allegations of abuse and maltreatment. I sat for 5 minutes, and then I quietly excused myself from the room, me, the acting clerk, because I was overwhelmed with emotions of witnessing a child having to give evidence in their own courts. I don't know how she did it, but Justice Bain was skilled at making children feel comfortable, valued, and involved in her courtroom. It was only a few months later, the night of my EDLS graduation, when former senior tutor Mama Hazel, Senator Hazel Thompson-Ahi, she pulled me aside that night at the graduation and she said, "Now that you are a lawyer, don't just go out there and practice law. Go out there and make a difference. Let your work count." And that was when the beginning of my journey as a child rights advocate started, after many years of previously working as a youth advocate. I've been given the subtopic of the advocate and the child in custody. But before I get to that subtopic, I just want to very quickly talk about the overall topic, which is juveniles and the law, the juvenile justice system in the Bahamas. The truth is, and this is my view, we do not have a juvenile justice system in the Bahamas. I place emphasis on the word system, and I will come to that very shortly. Instead, what we do have is an ad hoc approach of untrained stakeholders working in silos without consultation or collaboration, who fail to provide streamlined child care plans for children in conflict with the law. Why do I say this? Well, let me define what is a juvenile justice system, and then you can tell me if such an arrangement exists. A juvenile justice system is a multi-stage system that is separate and apart from the formal criminal justice system. It is designed to treat, keyword is treat, to treat children under the age of 18 who are accused of committing a delinquent or criminal act. And I'm talking about treatment. That system includes stages like delinquent behavior, referral, intake, diversion, which is also disposition, transfers, waiver, detention, adjudication, juvenile corrections, and aftercare. The majority of these stages are missing here in the Bahamas, or where they are present, they are ran by independent agencies and organizations who do not collaborate with each other. Instead, in the Bahamas, most of these agencies are territorial and they are competing, like social services, national security, legal affairs, education, Ministry of Youth, Sports and Culture, even the judiciary, the DPP's office, the Royal Bahamas Police Force, and a limited number of NGOs who have never sat alone together in a single room as all stakeholders to coordinate an individualized care and treatment plan for children before the courts. Something Mama Hazel always taught me was the emphasis on individualized treatment for every child, because it cannot be a one cap fits all for every child that comes before the court. Having now presented an argument as to the absence of a juvenile justice system in the Bahamas, let me quickly turn to the role of the advocate. I recall my early days at EDLS when each term began with the student orientation process. Brian Marie QC, who is now our Lord Chief Justice, was the managing partner of a local prestigious law firm, and he was a regular, I might add, favorite speaker each year at that orientation process. We always knew what he was coming to talk about because we had heard it the year before. But that never stopped him from drilling into us the single message that there's a need for specialized attorneys. What I have come to learn over the years is that juvenile defense work is indeed a
Mr. Smith, I think you may have muted
your
yourself.
mic is on mute. You're up now. Go ahead.
Okay. It is not an area of law to cut your teeth in, so to speak, or to get your feet wet. This is because children are different from adults, and they have considerations such as school, parents, ongoing brain development, and a number of other competing interests that attorneys who represent children need to be aware of and familiar with in order to provide high quality defense representation. Senator Hazel mentioned the various sources of law for juvenile rights, and I won't go through them, but I placed them up there on the PowerPoint. For us here, we started the Child Protection Act in the Bahamas, and then primarily the CRC, which is the UN Convention on the Rights of the Child. But there are many other international treaties, communiques, and guidelines to speak to the treatment of children before the courts. When I started representing children, many of these I have never heard about or knew what they were. It wasn't until I met a child who had been before the courts from the age of 11 years old with an outstanding case that had restarted on 3 different occasions. It was then that I realized I needed training and needed it fast. At age 11, that young man had been charged with unlawful sexual intercourse with another minor, much younger than he was. Throughout the entire case, all the attention, resources, and emphasis were placed on the young female child, the victim, but no one ever bothered to stop and ask whether he too was a victim. Apart from the obvious difficulties like being able to take clear express instructions from the child, mitigating his trauma, navigating the toxic home environment he lived in, and the fact that he had been put out of school, that case demonstrated to me the widespread systemic abuse that children face when they come before the courts. It was thanks to the training opportunities from Epiphany Chambers led by Hazel Thompson-Ahi, the US State Department, CARICOM, Commonwealth, and other agencies that I learned about the relationship between the advocate and the child. This was a new concept to me. Some of the cornerstone principles that a properly trained juvenile attorney would need to acquire are as follows. The duty to represent the child's express interests. And this is very different than the best interests. Sometimes what I have found is that the child's express interest is in competition or competing with the interests of the parent or the interests of the state, even the interests of the court. How do you deal with the competition between the child's express interest as your client and what is in the best interest of the child? There's also the need to learn how to properly establish an attorney-client relationship with a child and what are the appropriate boundaries there. For example, giving the child your cell phone number, having private conversations with that child, meeting privately with that child, building the trust factor with that child. Diminished capacity also deals with the ability of the child to instruct counsel, understanding whether the child suffers from any ACEs, which are adverse childhood experience and traumas, and how does that affect the child's ability to understand and comprehend the system as he goes through it. Confidentiality and privilege. Even though the parent might be the one paying the attorney, confidentiality and privilege to the child client can never be breached. This was something that I had to learn. And parents found this very difficult when I could not divulge certain information to them. And they would say, but this is my child. I'm the one paying the fees. Protecting pretrial due process rights is also another important component, which is the right to be heard. The right to be heard can be expanded in terms of creating a comfortable environment so that the child can express himself to the court. His right to privacy, his right to his matter being dealt with in camera. Currently, our juvenile court sits within the Nassau Street Magistrate Court complex with a number of other courts where these children are within sight and sound contacts of adults who are not connected to their matter. When the child matter is called up, the clerk of the court goes out to the door and shouts out the name of the child or the parent to get the attention of the child that their matter is now being called. Anyone within sound contact now knows that that particular child has a matter before the court. Lockup, detention, and bail are also issues. Understanding that there's a separate bail regime for children. The need for them to be separated. And separate is no sight nor sound contact with any adult who is not connected to their matter. Understanding that the work of the attorney begins at the point of police interrogation, not at the point of arrest. Yesterday, I was reviewing a police statement in a juvenile matter where the parent attempted to interrupt the interrogation process by saying to the police officer, I want to stop this now, let me get an attorney. That police officer ignored the parent's request and continued interviewing the child and asking a series of questions. Also, accessing ancillary services. The mental health services that Jenna Christie just talked about, social services, school placement, and the biggest challenge that I have found is placement in terms of housing. Once we get these children out of the system, a lot of them cannot return back to their home environments, which are often toxic environments for them. I have a very quick chart here that explains the cycle of what our children are going through when they come before the court. In the US, most of you may have heard of the school to prison pipeline. But what we experience here in the Caribbean is more of a street to prison pipeline or a home to prison pipeline. It does not start at the school for us, it starts in the home. So if you look at the bottom right-hand corner, there's the social housing issues. There's violence, abuse, poor parenting, single parents home, desperate living conditions, unsafe environments, poverty, food insecurity. All of these are compounding factors that traumatize the youth. The children then moved into the school systems, our primary school, junior high school, middle school, some of them never making it into high school. That's why there's an X on high school. So from earliest primary school, we can start to discover the disruptive behavior in the child. Once they get to junior high school, they're being suspended or expelled or the police is called, and then they end up before the court, placed in juvenile detention center. Our boys and girls at industrial schools also have the capacity to refuse custody, to refuse to accept certain children for whatever reason. I won't necessarily get into that today. And those children are then transferred to the adult prison facility. So we have here in the Bahamas what is called the juvenile wing of Foxhole Prison, or the Bahamas Department of Correction, where there are children under the age of 18 in the adult prison system. We also know that our juvenile court is currently facing a serious backlog of cases, over 1,300 outstanding cases as of November 2019. A lot of this has to do with the challenges of how our juvenile court is set up. I'm going to end with a couple of recommendations for reform. One of the primary reforms is to need to establish a Department of Juvenile Justice, so that we bring all of the stakeholders together under one umbrella. That does not currently exist. I would like to see the introduction of a standalone Juvenile Justice Act. What we have done is we have incorporated the juvenile court provisions into our Child Protection Act, and there are deficiencies there within the Child Protection Act. The Child Protection Act makes provisions for the establishment of the Minors Advocate Office, but the Advocate's Office was never established when the Child Protection Act was passed. So we currently have children appearing before the court unrepresented. Children having to cross-examine witnesses on their own. And for those of you who are attorneys or aspiring attorneys, you know that the skill of cross-examination is a skill that takes many, many years to master, that many senior practitioners leave the practice and never master. But children are now left to defend their own cases and to put questions to the witnesses. I'm currently advocating for a system that replaces our juvenile panel with a standalone, full-time, properly trained, right-tempered judge in a separate facility, one that does not sit within the current Nassau Street Court system. Or we allow the child to elect an option to be tried before a judge alone, because the panel is what is creating the backlog in our system. There's a need for mental health screening and assessment service, diversion and disposition services, and ensuring that policing standards for handling juveniles adopts the best practices. This quote at the bottom of the screen is a quote that I always end these kinds of speeches with. It's a quote from Nelson Mandela that says, "There can be no keener revelation of a society's soul than in the way it treats its children." If we are to measure the souls of our nations throughout this region, let's start by examining how we treat our children. I thank you very much for your time and attention.
Thank you so much, Attorney Smith. I have a couple questions. I've gotten some questions in the group. I will read 3 questions, one for each one of you. Dr. Hannah, you will go first, followed by Ms. Christie, followed by Attorney Smith. Dr. Hannah, your first question is, Dr. Hannah, considering the peculiar vulnerabilities of youth and children, who guides the protocols for the management of children in custody as it relates to the police force? How are these protocols aligned with international standards and the international rights of children? Supplemental to that question, who is responsible for policing the police in the management and treatment of children and youth in the care of the police? Jenna, your question. The end goal is never to stay eternally in state care. In your experience, are we preparing children and their families in these homes for reunification? Where have we fallen short? And should you have a relative having to spend 1 week in any of these homes or custodial care, would you be comfortable? Why or why not? Mr. Smith, your question. You've heard the stories and seen the faces of many young people. What is the one key thing you would change in the system? And what immediate change would you do if given the power instantly? Dr. Hannah, we'll start with you.
Good afternoon. I'm sorry, I didn't get all of the question. Can you repeat it, please?
I sure can. Considering the peculiar vulnerabilities of children, of youth and children, who guides the protocols for the management of children in the custody, children or youth in the custody of police care? How are these protocols aligned with international standards and the international rights of a child? Further, who is responsible for policing the police in the management and treatment of children and youth in custody?
Okay, thank you so much for your question. We have a rank structure in the police force, and we have different tiers of supervision. So we have a station officer who is responsible for the shift. We have an inspector, assistant superintendent, and ultimately we have a commander. So there's different levels of accountability and checks and balances to ensure that when juveniles come into custody, that everything, all of the policies and procedures are enforced. And ultimately, it's up to the officer in charge of that police station. Insofar as international standards, look, the police force is a member of the International Association of Chiefs of Police. We are connected to and have strong relationships with the international community on a vast variety of criminal justice issues, including juvenile justice. And we are continuing to strengthen our policies and procedures in line with international standards. So that exists now. We're also a part of the Association of Caribbean Commissioners of Police, which is a regional body. The IACP is an international body. And we work closely with the United States Embassy here in Nassau, with the Office of Law Enforcement Affairs, International Law Enforcement Affairs, who also assist us with making sure that we meet our international standards. And your last question about who polices the police, let me tell you this. Since the George Floyd incident in the US last year, the law enforcement global community is going through massive changes in terms of civilian oversight and who looks over law enforcement. And I can tell you this, you're going to see more and more changes in the criminal justice system, particularly in the field of law enforcement, when it comes to civilian oversight, because yes, that question about police being responsible enough or competent enough or impartial enough to police itself is one that's going to stick out like a sore thumb. And while we have capable persons, yes, you want to appear to be as independent and impartial as possible. So you're going to see a lot more in terms of civilian oversight, dealing with not only juvenile justice matters, but also complaints lodged against the police. So all of that is going to be something that's going to be strengthened in the near future.
Okay, thank you so much. And Dr. Hannah, I want you to just put this question in your head. I'm going to move over to Jenna. But one of the other questions that came up for you is listening to these wonderful initiatives by the Royal Bahamas Police Force that are ongoing. How accessible are these programs for youth with disabilities? As access is a human right, is it still a barrier for people with disabilities to engage the frameworks that are designed for development? And you spoke about quite a number of initiatives that the police are doing. And I think that is to speak directly. How do we deal with that particular community? Jenna, we'll go on to you for the answering of your question, and then I will give you your second question for consideration and come back to you. You're on mute, Jenna.
Right,
Okay, and
yes, okay.
it's so wonderful that we have
One second,
technology
Dr. Hanna, we'll come back to you. I'm just
because
going to go to Jenna
via tech.
first.
Oh, go ahead. That question
Yeah.
was for someone else.
No,
Go ahead.
it's for
I'm
you.
sorry. Go ahead.
It's for you, but I'll come back to you on the answer. Go ahead, Jenna.
Okay, I believe the question was about whether or not the current system as it stands right now is preparing both all the
Correct.
parties involved for reunification. In my honest opinion, I do not think that it does. I think that our system is so heavily overwhelmed that we have the intention to do so, but we do not have the adequate manpower and we do not have the continuity of care, the full wraparound care that we would like to have for the children. So even though we have the facilities in place, even though we have dedicated persons in these positions, I do not think that the way that the system operates presently is giving adequate preparation. And not just to put the blame on the system, because as we all know, persons need to want to change and need to want to accept these resources that are at hand as well. But as it stands now, I do not think that we are fulfilling the mission that we want to do because we are rather restricted in terms of how we interact with one another and what we need. And I think the second part of the question was, how would I feel if my loved one was in one of these facilities, correct?
Correct.
I would be worried. I do not feel 100% satisfied, once again, for the same reasons as for the initial answer. We do have persons there who are competent. We have people who are knowledgeable. However, we do not have the integration of these systems. We have too many systems for the child that are working independently and not in proper conjunction with each other. That we have, I think it's what Savari said, they're all operating in silos. Well, this one has, that's not under my job description. I don't do that. I don't do this. And it's impacting the child in a negative way. I feel that there's also the consideration of, once again, are we putting the right children into these right areas? Are we doing everything that we can actually do? Do we have all of the resources that we need? Because we can see the problem, but because of the lack of resources, do we have the solutions, the proper solutions?
Thank you so much, Jenna. And Tavari, we'll go over to you.
Yeah, so very quickly, given the power, what would I do immediately? And I hope Magistrate Cara Turnquestable is still here. Maybe she can assist with this answer as well. I'm not ashamed or afraid to say that I'm very biased towards this particular judge. I've been appearing before her for a number of years, and her expertise and skill as it relates to dealing with our children is something that I truly admired. But if given the power immediately, one of the first changes that I would make would be the juvenile panel. I understand the need for the panel, why it works, how it works. The fact that what's supposed to happen is you have a single magistrate who sits as the chairman of the panel, and then that magistrate sits with two lay persons or lay magistrate, one of whom must be a female. The juvenile court only sits 3 days a week, Tuesday, Wednesday, and Thursdays. In addition to that, it is constrained by the schedule of these lay persons who are volunteers. And so if a particular matter or trial starts before that particular panel, you must wait for that panel to be available again to continue that matter. And that creates a number of delays and backlog within the system. Currently, since COVID has started, we have not had any juvenile court sitting. We've done a lot of case management over the past year. And that's primarily because of how the panel sits. You have three persons who sit in close proximity, and so the court has to be retrofitted in order to accommodate three persons sitting at the same time. One of the things that I would have liked to have seen, and I put it to the politicians earlier, was when they were passing all of the emergency regulations, was that we ought to have given this particular magistrate the authority to deal with some of these matters as a judge alone. allowed certain juveniles on the advice of counsels, if they so decided, to elect to be tried before a panel or elect to be tried before a judge alone. And the reality is all of our children do not go before the juvenile court. If that child is charged along with an adult, they go to one of the other adult magistrate courts. If that child is charged with an indictable offense, a VBI is presented and that case is then transferred to the adult Supreme Court. So we're still not even capturing the majority of our children who get in conflict with the law, who come in contact with the legal system. It's a small number, I think, though it's still a large number, but it's not the majority of all of them who come before the courts. And so that would be my first recommendation, is that we deal with the juvenile panel system, because that is creating the backlog. We have a competent, well-trained, experienced magistrate who knows the law in this area, and she can move these matters quickly.
Okay, so Dr. Hannah, we'll go back up to you in reference to the question of managing individuals with disabilities in police care.
I'm sorry, could you speak up just a little louder for me, please?
In reference to the discussion, so one of the questions that came for you, which was listening to these wonderful initiatives by the Royal Bahamas Police Force that are ongoing, how accessible are these programs for youth with disabilities?
Yes, thank you for your question. I was making the point that through technology, it increases the level of accessibility. For example, the National Neighborhood Watch Council has an active Facebook account. They have regular Zoom meetings. They use WhatsApp groups in the communities. So through technology, it makes it extremely accessible. Websites, as I said, Facebook accounts. So it's accessible. And I think there was a second part of the question. Was there another part of the question?
No, that's the gist of that question.
Yeah, pretty much technology. And thank God for Zoom, Facebook, and all the social media outlets. It really bridges the gap in terms of accessibility. So all of those programs can be accessed. And the Royal Bahamas Police Force, we have a website, royalbahamaspolice.org, with links to all of these programs and entities.
Okay. Jenna, mental health is key, and many children in these homes come in with a number of diagnoses, as you had stated. In your professional opinion, how are we managing these young people today, and what do we need to do to improve this?
I think that the way that we're managing them right now is that we overutilize San like Rehabilitation Center a lot. I feel that they have to deal with the children, not just on the mainland. They deal with children on the family islands. We have only one psychiatric facility offering inpatient. We need to be able to spread these resources around, and we need to be able to properly train the workers. You do not, everyone does not have to be a psychiatrist. Everyone does not have to be a mental health therapist. But what you can do is you can teach how to deal with these situations. Here at the Grand Bahama Children's Home, we have a training program for our staff where we discuss the mental health issues, where we discuss attachment, we discuss self-harm, we discuss how to deal with temper tantrums. We have extended this knowledge to the people who are dealing with the children the most. You do not always have to have the people coming in make do with what you have right now. And we have the people who can teach this information, and we know where to find those who need the information the most. So I think if we can start there, start within the homes and start with giving them the basics, that will, we can learn to transform how we handle the children, how we can maintain keeping the children into their homes or into whatever outside government facility that is non-correctional. And then we can go to more intense interventions as need be. But it's possible. We're doing it now in Grand Bahama.
Okay, thank you so much, Jenna. And Tavari, I have one question for you. What has been your greatest triumph in changing the system, and what is the most significant thing that you believe we are failing at? Are we failing today's youth involved in state care, or are we succeeding in traversing these young people into normal life?
The greatest triumph is not something that I can take credit for myself, because there were a lot of people involved in this particular case, and it's the case of R.B. a Juvenile v. the Attorney General. Started in the Supreme Court and it went to the Bahamas Court of Appeal. It's on the Court of Appeal website if anybody would like to have a look at it. Yourself, Turnquest, Jenna, others were involved in that case. Hazel Thompson he gave me a lot of legal advice in that case as well. But it was a case that dealt with creating the special bail regime for juveniles, children in custody, and how do we treat the children who are in custody. That case involved a young man who had spent 2 years on remand, up to 2 years on remand, waiting for his trial to start, and he had been refused bail. And it was in violation of our Child Protection Act. It was in violation of the UN Convention on the Rights of the Child, which clearly says that detention must be a last resort. The most powerful thing about that case is what that case acknowledged was that the Bahamas has an obligation, as well as all of the other Caribbean countries as well. When we sign on to these international treaties and these communiques, we have an obligation to see that we abide by them. And that's what the Court of Appeal said. We signed on to the CRC, the Convention on the Rights of the Child. There was an obligation to abide by it. And we had incorporated it into our laws through Sections 3 and 4 of the Child Protection Act. And it was a landmark decision, which I think really created a new regime for how the courts are now treating children in custody.
Thank you very much, Tavari. I have one question that goes to anyone. How is the balance struck between the express interests of a child and the child's best interests? What variables are considered in striking such a balance?
I think I can start with that one because it came up in my presentation. I'll tell you the truth. The balance between the express interests of the child and the best interests of the child is something that I always struggle with. I don't know if I have found the right answer as yet, but what I have done is I have always reached out to professionals. A lot of the young people that I deal with, Jenna gave some statistics earlier. I think she said about 40 to 60% of the young people who come before the courts have some mental health issues. Majority of the young people that I represent, I reach out to persons like Jenna Christie, Mr. Darren Turnquest, Nadia Cash is another professional who provide mental health screening and assessment services for these children that I represent. And I use those mental health screening reports to determine the child's capacity to fully instruct me and the child's ability to understand the options that I'm putting to them. Because as the attorney, I'm working on a case right now. I won't go into any details, but I'm working on a case right now where the child can either decide we take this matter to trial and he try his chances before a jury, or we try and enter plea negotiation discussions with the AG's office. That's a heavy burden to place on a child. It's a very heavy burden to ask a child to decide to take your risk before a jury who might find you guilty and you end up with a stiffer sentence, as opposed to getting plea negotiation and you might possibly end up with probation. But nevertheless, the child's ability to instruct me is paramount in that, and me following their clear expressed instructions on what they would like to happen to their case. Not what their parents would like to happen, not what social services would like to happen, not what the judge would like to happen. What is the child's clear expressed instructions on what they want in their case? And it's one of those things that juvenile defense lawyers must be mindful of every single time. And anytime I'm conflicted, Jenna's always a phone call away, Turnquest is always a phone call away, and Nadia Cash. Those are the three professionals that I reach out to every single time.
Okay, we have another question for you, Mr. Smith. how can this standalone Juvenile Act be done? This is needed because children did not have a voice until you and your team came along after being a pit bull in a good way for the children of the Bahamas.
I don't know if I'm at liberty to go into plenty details today, but I can say that our current Chief Justice, Brian Marie, has established a committee, the ADR Reform Committee, and on that committee, there's a subcommittee that deals with youth ADR. Several of you here today are members of that committee, and that's one of the proposals that we are putting forward to the Chief Justice, is to adopt a standalone Juvenile Justice Act. Mrs. Hazel Thompson, he mentioned it early in her presentation as well, the fact that there was a template that was already circulated throughout the region. Grenada has adopted it with some modifications. Guyana has done the same. Jamaica took a different course with their Child Protection Act, and then they did a separate Diversion and Disposition Act to supplement the missing provisions. And then the OECS countries also have a Juvenile Justice Act. See, what happened to us here in the Bahamas is we used to have the Administration of Justice of Children's Act earlier. That act was repealed. We created the Juvenile Court within the Child Protection Act, which is now this very cumbersome compendium of documents that we now have to flush our way through it in order to understand what's supposed to happen. And sometimes those provisions are competing. One of the things I often find in competition is, for example, sentencing. Before the magistrate can sentence a juvenile, the magistrate must get a social service report, a sentencing report from social services. That creates delays in and of itself. And so it can be months before that report is available, and the magistrate hand is then tied in dealing with the child because they need that report in order to deal with sentencing. And it's happening in the adult courts as well, where there are probation reports or psychological reports being requisitioned by the court. The Juvenile Justice Act would deal with a lot of these inefficiencies and deficiencies we currently have. The countries that I've mentioned earlier, they have working models that we can visit. We can see what works for us, what doesn't work for us, and we can modify it in a way that is unique to our landmass as a island nation, or many island nations in the Bahamas, because that's something that we have to take into account as well. The fact that we don't have a juvenile court on every single island. So what happens to those children who end up in court matters where there is no juvenile court? They have to appear before a judge alone. And so it's about equity, as Ms. Thompson mentioned earlier.
Okay, thank you very much, Mr. Smith. Dr. Hanna, who keeps police officers accountable? I think you would have handled this, but who keeps police officers accountable for the mistreatment of juveniles that are processed through the system? Also, why is it that the Simpson Pen / Girls Industrial School has the right to deny a child the ability to stay in the facility? How is it that a child can be sent to prison and not an institution made for them?
Okay, insofar as the sentencing goes, that's outside of the remit of the police force. In terms of the child going to BDOCS or one of the schools, that is in the remit of the judiciary. Insofar as who keeps the police accountable, it's the members of the public. Members of the public keep the police accountable. Sir Robert Peel, the father of policing, stated that the police are the public and the public are the police. The only difference is that the police officers wear a uniform and work full time. But it's the members of the public who keeps the police accountable. When you find a police officer, or you have information a police officer is doing something outside of his or her duties, whether it be juveniles or otherwise, you have to bring that to the attention of the police force. We have a complaints and corruptions branch at police headquarters. We have a number of advocates through the Ministry of National Security. We even have public advocates. And there's a Bahamian saying that pressure bursts pipe. You have to demand the way you want to be policed. We are your servants. You pay our salaries. And so ultimately, members of the public are responsible. And as I said earlier, since George Floyd's death in the United States last year, you're going to have more and more civilian oversight with the police. And I'm talking not only in matters of complaints or criminal matters, but I'm talking right down on the front end in terms of recruitment, members of the public having a say in who should be hired, who possesses the skill set to become a police officer. And so you are going to see more and more of that coming. And it's so interesting to know we are going back to Sir Robert Peel's principles way back in 1829, putting the public in charge, putting the power back into the realm of the public. And so, you know, wherever we're in the police force, we know that police officers are human beings. These police officers do not fall from Mars. They are a product of our Bahamian society. And when they go afoul of the law, they are responsible. They know right from wrong. And if they are culpable, they will be dealt with, whether it be by firing them, reduction in rank, or sending them to jail. And you have numerous cases of that. Last year, police officers who have been found culpable, they are in prison right now. Nobody is above the law, and nobody is beneath the law. But back to the main question, members of the public hold police officers accountable.
I want to posit something there, Dr. Hanna, just from my experience, and something for consideration as we go through this very rich dialogue. Having worked in Boston for a number of years and working with state police and county police there, one thing that is always an opportunity is police officers actually filing on themselves, or filing on each other, or filing on the department or the agency that is in the care of the child, filing on themselves for an independent investigation to be done by the Department of Social Services. And so in that case, if you had somebody working in a group home, or you had a police officer who witnessed a particular rough handling of a child, it would be standard protocol to file that as a potential child abuse that needs to be investigated, so as to, one, protect the interests of the child, but also protect the interests of the officer. And I leave that in the discussion, because I think when we talk about the public, I think a consideration has to be, and both Jenna and Tavari, you can weigh in on this, consideration has to be, it can't just be the public, it has to be a particular body that is responsible for preventing cruelty and preventing the mishandling of our young people, and also enforcing the rules, regulations, policies, and international laws that are out there in the handling of young people. So I put that posit there in the group. But I also want, we've had an exchange about young people in prison, in BDOCs, and there being a wing in BDOCs. And we have great panelists here from the policing aspect, or the law enforcement aspect, to the mental health, to the law aspect. How is this happening in our country, and what are our next steps? So I want to frame that in terms of our final wrap up. The considerations that we've had is, one, how do we take care of our young people correctly? What laws do we need in order to, the change of laws in order to take this into the next step or the right direction? Is it okay for us to have young people in BDOCs? How do we police each other to ensure that we are not being cowards and that we are whistleblowing when our colleagues are doing wrong, either in the home or whatever state care this young person might find themselves in? And of course, how is it that we are improving the resources available to young people in state care? And I'm going to give, those were the themes that came out in this discussion, and not to forget the disabled community as well, the differently able community. And I want us to just wrap up. So I'll give everyone 2 minutes to just give us a wrap up so that we can bring this to a close. We are going a little over time now. Tavari,
I want to put this to Jenna very quickly, because I don't know if you guys are aware, but Jenna actually worked at one of these institutions. So when you hear us talk about Boys and Girls Industrial School or Willamette Pratt Simpson Parent Center, these are the same institutions. They just have different names, or we refer to them in different names. Unfortunately, the Child Protection Act makes provisions for it to happen. So the children can be sent to adult correctional facilities under our Child Protection Act. I think that's where the injustice starts. A part of that problem is also the fact that these institutions are very strange to me, and they've always been strange to me. I recall a case that we had at the Court of Appeal where the law lords were questioning whether the child had the opportunity to leave the facility to attend outside schooling because he was more advanced than the Penn Pratt School syllabus that he was currently getting while a resident at the school. And nobody from either of these sentences could answer the law lords. The question went unanswered. The law lords asked for the rules and regulations that govern these facilities, and we're still waiting on them today. Jenna mentioned the fact that these facilities are being used to house children in conflict with the law, as well as children who are in need of care and placement. So you have children who are before the courts on criminal matters in these institutions, children who are before the courts in delinquency matters in these institutions, and children who simply have nowhere else to go because there's no more spacing at the children's home in these institutions. And we're mixing these three groups together. And so it's creating this conflict. And so what you find happening then is the administrator of these institutions decide that, well, we will take the delinquency because we can deal with the delinquency better than we can deal with the child who's charged with armed robbery or the child who's charged with grievous harm. Send that one to the adult facility because he has a much more heinous or serious crime. And so that happens because we've not fully defined what these institutions are. We call them juvenile detention facilities, but they don't live up to the name, and they're not that by any standards whatsoever. And that's not an attack on the hardworking staff at these institutions. That's an attack on the system that we think we've created for these institutions to function.
Thank you so much,
Yes.
Mr. Smith. Go ahead, Jenna.
Yes, Tavari, exactly what you said, that is the case. Now, to provide a little bit more clarity on the children being sent to BDOCS, Bahamas Department of Correctional Services, it is just what Tavari said. Sometimes we do have, when I was there, we had situations where some of the children who were more disruptive, who were more aggressive, who posed a significant threat to the safety of the other children who were there. We had to sometimes make the executive decision to appeal before the courts to say, okay, how can we remove this child? Because we need to preserve the other 20 children who are there, because there is such a mixture of reasons as to why the children are there. Now, while I was placed at Willie Mae Pratt, we did have a separate section, some separate buildings that were known as the cottages, where children used to be housed, but major renovations needed to be completed for them to be properly utilized. So part of what we're saying also is the systemic situation where, can we get these other buildings up and running so you can properly segregate between those who are there for care and placement until we can fully address that issue on a wider level, as well as keep those who may be there for more serious offenses, those who are highly unstable, who pose a risk and a significant threat to the other children. How do we keep them isolated in a safe way away from the Department of Corrections? And that's where we look at the state, or we look at, the heads of social services to bring about solutions to these things, because the grounds are there, the facility is there. We need the proper renovations for that, so we can at least work to eliminate that problem of having the children sent up to the Department of Corrections, and rather than keeping them where we are.
Thank you, Jenna. Listen, these are some wonderful, wonderful interventions and a great discussion about things that we need to do to get this right. The question is, how much collaboration do we have, multi-agency, cross-sectional collaboration? And Dr. Hannah, we're going to turn it over to you, a very informative presentation. And the interesting part is that sometimes this starts with the police. And the question is, how does it start? But more importantly, how does it end? And so we go right over to you, Dr. Hannah.
Yes, thank you so much. And look, my final minute or 2 minutes, I would just say, I look at things a little bit different. I think we need to really strengthen the attention on the prevention side, to lower the number to an irreducible number of the juveniles who come into contact with the quote-unquote non-existent juvenile justice system. And I think we need to go back to the family, go back to parenting, go back to members of the public, you know, maybe driving down the street and seeing two kids cursing at each other and say, hey, that's not the way you talk to each other. Talking about drug prevention, demand reduction, educational attainment, and employability. I think these are the solutions, because if we don't stop the numbers on the front end, more and more issues are going to come up on the back end. So I look at it a little bit differently. And, you know, as I said, the police are the gatekeepers of the criminal justice system and the juvenile justice system. And I think all of us are stakeholders, while we make sure we protect the rights of the child at whatever stage they are in. I think we need to, you know, just stop for a minute and just realize that we're talking about kids and we're talking about family, parents, public, making sure that our kids are properly educated, our parents, making sure that kids do their homework, because we know that there's a relationship between educational attainment and the risk of a child becoming involved in antisocial behavior. We know that there's a correlation between the skills that a child have, employability skills, and their risk for making a living through illegal means. We know that there's a relationship between kids who start out with drugs, including alcohol and smoking, that they move on to other drugs. And, you know, when you're talking about drug use, you get into drug abuse and trafficking and gangs and guns and all this stuff. So I think the answer is really prevention. All of us in our appropriate positions need to put some effort into that part of it. And as I close, for my little time, I just want to say to Vari Smith, who is one of my former students at COB, I am very proud of you and the work you are doing, and it is very good to see and hear you again. So thank you so much. Back to you, Mr. Moderator.
Thank you very much. Today we've covered so many topics and so many themes in reference to the juvenile, in reference to the child, in reference to the youth, whichever name you'd like to call. We've looked at the accountability of individuals who are responsible for these young people in state care. We've looked at legislation. We've looked at what are the resources that are available. We've looked at the idea and concept of mental health. But I think what we need to look more at is we need to look at the cross-fertilization and the exchange between a multi-agency approach to how we handle this in this country. The question is, who is going to do it? Who is responsible for bringing these stakeholders together to bring about the necessary reform at all levels? That question is maybe closer to what needs to be done, but definitely the question is not answered. Many young attorneys are here, social workers, future attorneys, future social workers and students. It is not simply one who has to be in the position to make a difference, but it is all of us who must make the system accountable to what it should be, and also those individuals to take the advocate's words and make the system even better than what it is. We want to be best in class. We want to be best in the region, but more importantly, we want to be best in the world. Young people are not the future, they are the present. So let's see how we make this happen. It's been a privilege and a pleasure to serve as your moderator for this session. I wish you every success. Thank you so much. And back over to Mr. Carey.
This time, I'm going to invite tutor Mr. Kevin Farrington to bring remarks on a vote of thanks.
Thank you, Mr. Gary. On behalf of the principal, Mrs. Tonya Bastian Galanis, the director of the Legal Aid Clinic, Ms. Nicole Sutherland King, the faculty, staff, and students of the Eugene DePuy Law School, I would like to extend our profound gratitude to our honorable speakers. Senator, the Honorable Mrs. Hazel Thompson-IE, you are passionate about your work, and that passion was manifestly demonstrated in your presentation that was replete with your personal and professional experiences. Your presentation, my lady, as always, well-received, well-researched, audience appropriate, and a consummate representation of the legal profession. We are grateful for your continued support of the Eugene DePuy Law School. Magistrate Tara Turnquest DeVoe, Your Worship, in the words of Busy Signal, one phone call. Your Worship, you are always one phone call away, and you never hesitate to demonstrate your eagerness to assist in the matriculation of our students here at the law school. And for that, we are forever grateful. To my former law enforcement colleague, Dr. Charles Walhana, Superintendent of Police, I've had the opportunity and the benefit of working along with Dr. Hanna during my laborious stint within the police force, and I sat in the front pew as he facilitated training for thousands of law enforcement officers within the Commonwealth of the Bahamas. I can personally attest to your dedication to your work and your passion in ensuring that training is at the forefront for law enforcement officers. We say, Dr. Hanna, thank you. Plot twist. Ms. Jenna Christie, you brought a different perspective to the discourse. Not only an academic, but you are a soldier in the field. Oftentimes we focus on the substantive law, but neglect the mental aspect of our young people. Our kids have stress too, and as quite rightfully highlighted, childhood traumas usually manifest itself to something more sinister in adulthood. Ms. Christie, we say thank you. I have known Mr. Tavares Smith, counsel and attorney at law, for more than 10 years, and I could say without fear that he's a gladiator before the juvenile court. It bears repeating, and I quote, one phone call. And I was able to assemble a cast of super friends who are passionate about young people. Your passion, as always, was stimulating, provocative, and timely. We thank you for your candor. We thank you for your experience and research. We thank you for your continued support of the law school. We would also like to express our gratitude to our esteemed moderators, Mrs. John Carey, attorney at law, and Kay Darren Turnquest, psychologist. Mr. Carey is actually in Papua New Guinea, and it's about 4 a.m., actually 4:09 a.m. on Friday, February 12th. Mr. Carey, we thank you for your dedication in this regard. Mr. Turnquest, Your Grace, you always bring a certain bravado to the discourse. We thank you for taking the time out of your busy schedule to assist us with this event, and we look forward to your continued support and partnership with the law school. A special thank you to you, the audience, for your patience, and your participation in making this webinar a resounding success. Unless there's anything further, Your Grace, this webinar has officially ended.